Good morning, sir. Can you see and hear me?
Yes, thank you.
This morning we're going to hear from Susan Crichton. I should just say before we start that we're going to trial a new break system where we're going to have two breaks in the morning, one around 11 o'clock and one around 12 o'clock.
I'm very grateful, Mr. Blake. Thank you.
Thank you.
I swear by Almighty God.
I swear by Almighty God
That the evidence I shall give.
that the evidence I shall give
Shall be the truth.
shall be the truth,
The whole truth.
the whole truth,
And nothing but the truth.
and nothing but the truth.
Thank you.
Thank you very much. Can you state your full name, please?
Susan Elizabeth Crichton.
Ms. Crichton, you should have in front of you a bundle of documents that contains your witness statement.
I do.
Could I ask you to have a look at that witness statement? It should be dated the 30th of January 2024.
Correct.
And it has the unique reference number WITN 00220100. Could I ask you please to turn to the final substantive page, that's page 107.
Yes.
Can you confirm that that is your signature?
So this was signed on DocuSign?
Thank you very much. And can you confirm that that statement is true to the best of your knowledge and belief?
It is true to the best of my knowledge and belief.
I believe there are some small corrections that you would like to make within the text.
That's correct, yes. Do you want me to go through those?
Absolutely.
So paragraph 47, the penultimate line, 3939 should be amended to 39. Paragraph 77, line 2, delete the before horizon. The heading preceding paragraph 95, initial response, needs an extra S in response. Paragraph 193, line 4, they should be the. Paragraph 260, line 8, long-term issue should be short-term issue. Paragraph 260, the penultimate line, Altman is struck through and should be reinstated.
Thank you very much. That statement is now in evidence and will be uploaded onto the inquiry's website shortly. Also, before we start, I believe there's something else that you'd like to say.
Yes, thank you. So I want to begin by saying how to all those who have suffered, families, friends, sub-postmasters, Crown Office workers, that I am truly sorry for the suffering caused to you and your families. I wish that things had been resolved more quickly, and again, I'm very sorry that they haven't been. I'm here today to give my evidence to the inquiry with establishing the facts and to try and ensure that something like this never happens again. Thank you.
Thank you very much. By way of background, you were admitted as a solicitor in 1985, is that correct?
Yes.
Yes, and you worked for a number of companies before joining the Post Office, a subsidiary of Midland Bank, Avco Trust Limited, GE Consumer Finance, where you ultimately became General Counsel of Europe, Middle East and Africa, and also Scandia International, where you were Head of Risk and Compliance. Is that correct?
That's correct, but in relation to the Midland Banks, I wasn't a qualified solicitor, I was a legal graduate.
Thank you. And you joined the Post Office in 2010 as Head of Legal.
That's correct.
You've made clear in your witness statement you didn't at that time have any experience in criminal law, and indeed you've said in your statement that the job description was for a technically strong and highly commercial lawyer. Is that correct?
That is correct, yes.
You were the Post Office's first Head of Legal?
It was badged that way because it was to move forward to the separation. The role had been filled previously, but it was part of the RMG legal team.
Thank you. And you had a number of other badges during your time. Those included Company Secretary for a brief period between January 2010 and July 2011.
That's correct.
You became Legal and Compliance Director in April 2012 on separation from the Royal Mail.
That's correct.
At that time and from then on, you had a direct line of reporting to Paula Venables, the CEO.
Yes, that's right.
Mike Young is a name we'll see. He was the Chief Operating Officer of the Post Office.
Yes.
And you've said in your witness statement, and we'll come to it, he was responsible for various IT matters.
Correct.
But when he left in 2012, you were assigned responsibility for the security team as well.
Yes, I think I say in my statement that we'd started to look at and think about the culture of the post office at that time, and there was a view that we should re-look at security and its role within the organisation.
And that fell from 2012 within your remit.
That's correct.
For some time, you were also HR and Corporate Services Director. Is that from September 2012?
I'm sorry. Yes, I think it was around that time.
And how long were you in that role for?
So that would have been just under a year, because when I think I went back to being General Counsel or Legal and Compliance Director in July 2013.
Absolutely. So from July 2013 until your departure, you were then called General Counsel.
That's correct.
But before that, you had various wide areas of different responsibilities.
That's correct.
And when did you leave the post office?
So I left at the end of November 2013, in the sense of I had actually left the business, if you will. An announcement was made at the end of September 2013. I think, as I say in my statement, I was on holiday for much of October, and I went in briefly to do a handover, and then during November I was on gardening leave.
Thank you. And after that, you left and joined Lloyd's TSB, where you worked until 2018.
That's right, when I retired.
Thank you. I'm going to ask you various questions about corporate structure, the use of external lawyers, and various other topics in due course, probably this afternoon. But I'm going to start this morning broadly chronologically, looking at bugs, errors, and defects, and also the involvement of Second Sight. In terms of knowledge of bugs, errors, and defects, perhaps I can start with your witness statement. That's WITN 00220100. And can we start, please, on page 6? Thank you. If we look at paragraph 16 at the bottom of page 6, you say there, until his departure in 2012, Mike Young was the Post Office Chief Operating Officer. His responsibilities included IT and change procedures, cash in transit, security, and procurement. When Mr. Young left, I was assigned responsibility for the security team. If we could please move on to page 10, paragraph 27. Can you assist us with exactly when Mr. Young left at all?
So from looking through the documentation, I don't recall exactly, but I think it must have been sometime in March 2012. I wasn't sure whether it was before or after separation.
Thank you. Paragraph 27 is in the context of the Computer Weekly article. And it says there as follows. It says, regarding any awareness of the board and or senior management team of the presence of bugs, errors, defects highlighted in the article, my understanding was that the responsibility for investigating such matters would have been with Mr. Young. His remit included oversight and supervision of the post office IT functions. Moving please to paragraph 36, page 13. In this paragraph, you address an article that's published in Private Eye, and you say the response at the executive meeting shortly following the publication of the article by Private Eye was along the lines that there were no systemic issues with the Horizon system and was given by Mr. Young, who had oversight of IT as part of his remit. If we go over the page, paragraph 37, you say there that you understood Mr. Young had a detailed understanding of the Horizon system and close knowledge of its operational function. The next paragraph, 38, the executive team became aware of allegations against the Horizon system in the context of complaints received from sub-postmasters or MPs. When an allegation or complaint arose, it was my understanding that the IT and network teams would consider the matter and would test the system to the extent necessary to assure themselves regarding the concern raised. Are we to understand it from those passages and overall from your witness statement that you see Mr. Young, at least between 2010 and 2012, as being responsible for the investigation and communication to the executive of matters relating to bugs, errors and defects in the Horizon system?
That's my recollection, yes.
Can we please look at poll 00409718? I'm going to start in October 2010, so within the first year of your arrival at the Post Office. And this is an email from Mandy Talbot to you, Hugh Flemington, who we're going to hear from in a week's time. He worked in Post Office Legal, is that correct?
That is correct, yes.
And Jessica Madron, who was she?
She worked in the legal team. She was part of RM Legal, seconded to Post Office.
Thank you. So Mandy Talbot, also a lawyer?
She was part of the RM Legal civil litigation team.
And you there are the senior recipient of this email?
That's correct.
And she says as follows, we need as an organisation to determine how best to deal with all the cases where allegations are being made about Horizon and where there is money owed by the former postmasters to the business. I'm compiling a list of the ones which have been sent down to me. Regardless of the true facts, these postmasters have all alleged that the true reason for the loss is the malfunction of the Horizon system. There are a number of issues which we need to resolve as a business about these cases before the decision is taken to send them out to BP. BP being Bond Pierce, I think. Is that correct?
That's my recollection, yes.
She then talks about the Seema Misra case, and she says, as I understand the prosecution case, the defendant's expert has been unable to find any fault with the system, but has come up with a number of opinions which have nothing to do with the case being prosecuted. Assuming that the case is concluded within the time period, some of the issues set out below will fall away. But if it is adjourned, or if we lose it, the following points will become relevant. Misra is the prosecution case involving Izzy Hogg, one of the lawyers used by Postmasters for Justice. If the prosecution is fully successful, it will make civil claims much easier to deal with. If the prosecution is only partially successful, then it is likely to make civil claims very difficult to proceed with if we cannot rely on the Horizon data. It says number 2, Postmasters for Justice plus Ms. Hogg and a lawyer from Shoesmiths are seeing the Minister at BIS this week about Horizon issues. We do not know what may come of this, but Mike Glanville may be able to give us a steer. And at the end of this email, she says as follows. She says, can I suggest that we have a conference call to discuss how to deal with these cases going forward, possibly on the 20th of October, as by then I anticipate that Misra will have concluded. Can you assist us? This is October 2010. Were you aware of issues relating to the Horizon system and litigation challenging the Horizon system earlier than October 2010?
So this was part of a relatively late disclosure. I'm trying to recollect when I became aware of it. I don't think I was, no. I don't think I was, but it's not my recollection. Certainly not from, that's not what I recollect. Obviously seeing this now, then things were being raised. And I think what I was trying to do was to look at this on a rounded basis. So I received this from Mandy, who was obviously a litigation lawyer in the RMG civil litigation team.
And as you said, you were the senior recipient of this email?
Yes, in the Post Office, yes.
Can we please look at poll 000555590? We're still in October, 21st of October, and this is an email that this inquiry has seen quite a lot of. It's the email from Jarnail Singh in relation to the Misra case, and it's where he says, it is hoped the case will set a marker to dissuade other defendants from jumping on the Horizon bashing bandwagon. And you were a recipient of that email, 21st of October.
That's correct.
In the email that we looked at earlier from Mandy Talbot, she suggested a call to discuss matters going forward after the Seema Misra case had concluded. Do you recall a conversation, a meeting once it had concluded?
I'm afraid I don't recall one, no.
Do you recall receiving this email?
Is that the one on the screen?
Yes.
Yes. Well, it was in the first batch of documents provided to me.
I don't mean recall from the inquiry providing it to you, but do you recall in your first year at the Post Office receiving an email from a senior lawyer in the criminal law division referring to the Horizon bashing bandwagon?
No, I'm afraid I don't.
Is it likely that that was sent to you in your capacity as head of legal of the Post Office?
It is, yes.
Yes. Can we please move on to, we're going to now move to April 2011. Can we please look at poll 00107-844? This is an email chain relating to the case of Ms. Odell. And if we could start at the bottom of the page, please. Bottom of the first page. We have an email from Rebecca Mantle, Head of Dispute Resolution at the Royal Mail Group. And it's sent to a very limited distribution list. It's sent to Alison Bolsover, who was at that time the Senior Debt Recovery Manager at the Post Office. Is that correct?
Yes, I think she gave evidence last year.
Yes. We also have there Rod Ismay, the Head of Product and Branch Accounting. Yes?
Yes, yeah.
And yourself. Why do you think this email was sent to the three of you about the case of Mrs. Odell?
So this is my recollection. I think at the time I was trying to understand this process that went through with regard to sub-postmasters and the civil litigation process, and to try and bring some element of proportionality to it as a commercial lawyer, to say, should we be taking this action given the likelihood of us being able to recover and the costs?
We may see these three names in other emails. Was there a particular reason why it was yourself, Alison Bolsover and Rod Ismay?
No, unless she thought we were the decision makers, but I would have said Alison Bolsover was the decision maker in this case, but I was the head of legal for Poll.
And who was the most senior recipient of this email?
I was the most senior recipient.
She says as follows. She says, I'm wondering whether the below case is one that it is worth pursuing. Mrs. Odell is claiming £290 from us. It would cost a lot more than this to defend, so I think we should settle this on the basis that it's not economic to defend such a claim. We could raise as a counterclaim the loss of £9,616, which we claim Mrs. Odell owes us as a result of branch discrepancies, which she claims are as a result of issues with Horizon. However, the legal costs of collating and preparing evidence to show that the Post Office suffered a loss and that it was not due to Horizon would exceed the value of the counterclaim. If we scroll up, please, there's a further email from Rebecca Mantle, again to yourself and Alison Bolsover and Rod Ismay. And she says, just to keep everyone updated, Alison and I have agreed not to defend Odell's claim on the basis that it would not be economic, even if we were to exceed in, or I think that must mean succeed in defending the claim, the irrevocable legal costs would exceed the £290 she is claiming. So, again, this is another email We're now in 2011 that relates to a sub-postmaster raising an issue relating to Horizon in her defence. Do you agree with that?
I do agree with that.
And it's your evidence, is it, that you were involved because you wanted to bring a degree of proportionality to these matters?
That's my recollection, yes. And I think in Alison's Bolsover's evidence, she mentions that I'd gone up to Chesterfield and we had a conversation about the Horizon cases.
Yes. Perhaps we can look at poll 00184214. The next month, May 2011. This is an email from a lawyer at the Royal Mail Group, Helen Watson, and she says, thank you. I'm copying in Chris Darville of Bond Pierce, as the case is now with him. This is about a different case, I think it's called Rake. Although currently on hold pending confirmation from Susan Crichton as to strategy on these Horizon cases generally. So it certainly seems as though Helen Watson had understood your role at that point to be advising on strategy of the Horizon cases.
Yes, and I think this goes back to my comment around proportionality, to try and understand what was going on with these cases and why we were bringing them and what had happened. So it wasn't necessarily driven by, I believe that Horizon wasn't working. I just wanted to understand the process and the authorisation process for bringing those claims.
You had a group of Horizon cases that you were aware of. Did you at this point consider whether the Horizon system itself should be investigated?
I think as part of this work, it was an iterative process of going back to the IT department to say, have you reviewed, or network department to say, have you reviewed all these cases? Can you explain to me how these shortfalls arose and convince me, because this is the way they operated, that this Horizon was not at fault?
And that's a conversation you had in 2011, is it?
It was, I think I mentioned in another place in my statement, but when complaints came in both from MPs or sub-postmasters, these were dealt with by IT, network, looking at the cases, trying to recreate the fact pattern, this is how I understood it, and explaining to the ET or me how this was not an issue with Horizon, but was a more general issue with the sub-postmasters, more mistakes had been made. That's what I remember happening.
You had joined the Post Office in January 2010. We've seen that by October 2010 and well into 2011, you were aware of sub-postmasters raising issues with Horizon, a growing number, and you have undertaken to review a strategy on the Horizon cases. Do you remember any specific meetings that you had with the IT department relating to Horizon cases in which you were reassured that there weren't problems with Horizon?
I think they would have been related to the specific cases. So I think what I would have done, I can't recollect one, but my normal practice would have been to talk to both the IT and the network team to understand why they were confident that these issues had not been caused by Horizon.
You said you address them as individual cases, but you are undertaking some sort of strategy review. Did you not look at them strategically?
Yes, that's right. And again, it was my background rather than, I'm not a litigation lawyer, but I was trying to understand that part of the Post Office process. And I relied upon the information given to me by the IT and the network team to demonstrate to me that these cases were not as a result of issues with Horizon, but were because of other issues.
And how did they demonstrate that to you?
So they would take a case, I'm trying to think of one, so an issue would have come in from a sub-postmaster, either direct from a sub-postmaster or from an MP, and they would work through the case and probably with these litigation cases as well, and demonstrate the entries that have been made, and I would and give me assurance that it wasn't caused by Horizon. I am not an IT expert, and I would have relied on their assurance about how it caused this loss or deficiency within the system.
You said they would give you a guarantee.
No, I didn't say they would give me a guarantee. I said they would give me an explanation, and it would be, in my recollection, it was a combination between senior people in the network and people in the IT team would look together at these, and often it would be network-led.
And can you assist us with some names, please?
So Angela van den Bogaard would certainly have been one. It may have been led by Kevin Gilliland, as he was responsible for the network, although Paula Venables was the overall director. I'm just trying to think and generally I would say Mike Young led on that for the IT side, although he wouldn't necessarily do the work himself, but he would be the leader of that.
Thank you. And we've seen both criminal and civil cases. Seema Misra case is an example of a criminal case. The Odell case is an example of a civil case.
Correct.
You then became Legal and Compliance Director, and from the 1st of April of 2012, you became responsible for those matters that had previously been managed by the Royal Mail Group, including criminal prosecution.
That's correct.
Can we please look at poll 00180229, please? So we're now on the 7th of June 2012, so post-separation. And this is an email from Jarnail Singh. If we could have a look at that bottom email. It's an email from yourself to Jarnail Singh about a case called Yetminster. And you say, if we decide not to go ahead with criminal prosecution, are there any risks for the Post Office? Am I right to understand that there was consideration being given at this time to dropping the case?
So, yes, I think so. In fact, Yetminster is the name of the branch.
Yes.
And because at that time we were having discussions with Alice Perkins and Paula Venables concerning an independent review of Horizon, which, if my memory is correct, we started having probably around about February, March of that. That was the first start of that, around February, March of that year. I was concerned that we would be going ahead with criminal prosecutions with the background that we had an independent review of Horizon starting to happen.
And why were you asking Jarnail Singh about the risks for the Post Office?
Because I wanted to understand his view. It was also my view, and I have said this in my statement, that I had asked for any prosecutions that relied solely on Horizon evidence to be ceased. Unfortunately, I cannot remember when I formed that view, but I know it was part of the work we were doing in relation to getting a independent review on track. It wasn't because I knew there was anything wrong with Horizon necessarily, but I just felt it was important that we paused these cases whilst we did the review.
Can we please look, perhaps if we could keep that one on screen and scroll up to the top of email, and we can also bring onto screen on the right-hand side poll 001372448. It seems as though in May of that year, there'd been a meeting with Lord Arbuthnot and Oliver Letwin. I think you attended a pre-meeting, a preparation meeting. If we please look at page 7 of this document. We can see there at 6B, that's the Tracy Merritt case. I think it's called Merrick on the left-hand side, but it's Merritt, and the Yetminster branch. And it said led by Susan. So it looks as though in May of that year you had personally reviewed some aspects of that case. Is that correct?
It looks like it, but I'm afraid I can't remember.
Are you aware that Ms Merritt had raised issues with Horizon in relation to her case?
Yes, I mean, I must have been, because that's the evidence there.
Thank you. If we stick with the right-hand side document, please, the left one can come down. Jarnail Singh says to you as follows. He says, as a prosecutor, Post Office Prosecution Ltd must be seen to exercise its judgment in all cases which give rise to potential criminal proceeding to promote effective, consistent and fair decision-making. If not, a third-party examination of our cases by, say, the Director of Public Prosecutions may result in withdrawal of our ability to prosecute. Was that a concern that you were aware of, a withdrawal of the ability to prosecute?
Was I thought we should, so to take a step backwards, our ability to prosecute was something that I'd raised with Paula much earlier in the year and said that we needed to review that. So I suppose honestly, no, I wasn't. I thought we should look at other ways of managing these issues.
He says, a decision to not to prosecute cannot be kept secret. Everybody will find out what we are doing. This may open Post Office to criticism and undermine faith in Horizon. This U-turn will be exploited by potential third-party sub-postmasters alliance. It may send a green light for defendants to get hold of their Member of Parliament and result in, I think he means capitulation rather than copulation. We need to send a message that post offices cannot be used as a bank. We hold a robust stance. Any wrongdoing will be investigated, prosecuted, and money recovered. Were you in any way concerned by that response?
I think it's fair to say, particularly given the fact that we were, and I was trying to push for an independent review, I didn't agree with that response.
Did you go back to Mr Singh and tell him those shouldn't be part of our considerations?
I think I might have had the conversation. I don't think there's a document showing I went back to him.
Pardon?
Sorry. I think I went back to him and said, or I explained that we were going ahead to, to set up an independent review, and as I felt there were other ways, or we should be considering our prosecution policy more generally. But I really can't remember, but that's what I likely would have done.
So you think, and it's likely, but you can't actually remember having done so?
Exactly.
Was that view that was expressed there by Mr Singh consistent with the views of the business more generally?
In my view, yes, it was.
And who in particular?
I think there was a group of people who had worked for the Post Office for a long time who held this view, and I think in my statement I mentioned it on a number of occasions that this was public money and that the Post Office should make efforts to recover that money.
You said a group. Who was part of that group?
So my recollection would be people who'd worked in the network, people who'd been in the business for a reasonably long time.
And who are those people?
I'm just trying to think. So Kevin Gilliland would have been the network director. Then there would be the group of debt recovery team in Chesterfield, and then there would be obviously not. So it would be the network. Angela van den Boogaard, Kevin Gilliland. I'm really searching for names now. I apologise, but that was my. It was this is public money and we need to protect it. That was the sort of slogan, if you will.
We've seen from these emails this morning, early on in your time at the Post Office and increasing, including when you had responsibility for the security team, you were aware of challenges to the Horizon system in the context of criminal and civil proceedings. And by May, June of 2012, is it fair to say that you were thinking about the impact of corporate decisions on criminal cases?
Yes, I think that would be correct.
Can we please look at your witness statement? You mentioned briefly about the continuation of prosecutions whilst these concerns were happening. Can we please look at WITN 00220100, and it's paragraph 255. Which is page 91. You say at the second half of that paragraph, 255, at some point around the time of the separation, I recollect I made it clear, including to the security team, that no further prosecutions were to be commenced, which were reliant on Horizon evidence. Now, it might seem that that wording there is quite careful wording. Can you assist us with what it meant? Reliant on Horizon evidence. How was that defined?
So, in my mind, it was prosecutions that relied specifically on the evidence produced by Horizon and the corroboration evidence. And again, forgive me because I'm not a litigator, was insufficient to outweigh that evidence. So, I basically wanted the teams to be very aware that they had a duty to review the evidence and to decide whether there was sufficient evidence to go ahead on that basis.
Was there some defined criteria that were sent to the security team and prosecutors in that respect?
I haven't seen a document like that, and I think it would be a conversation that I had, certainly with John Scott and certainly with Janelle. It might have been via Hugh Flemington for Janelle, but I was trying to heighten people's awareness about what we were doing.
Did you articulate it similarly to the way that you've articulated it to this inquiry, that it was cases that involved Horizon evidence where there wasn't much more than the Horizon evidence? I'm trying to understand the test that was applied.
Certainly, yes, I think that would be one way of looking at it, but it was a bit more than that. It was for them to really try and understand what had happened in the branches and why the sub-postmasters, if sub-postmasters were the issue, had got into this situation.
Is it fair to say that that didn't stop prosecutions taking place that involved complaints about the Horizon system?
I think that's right, from the evidence I've now seen.
If we look at poll 00180774, we're still in June of 2012, 20th of June 2012. And this is about the Merrick case that we were looking at before. If we look at the bottom email from Dave Pardo to Jarnail Singh, and it's copied to you above, he says, Jarnail, as this was a case whereby Horizon was being cited as being at fault, I'm not sure if we want to accompany the change in stance with a carefully worded missive stating that our position is not an admission of Horizon integrity issues. As it stands, one of my security managers has been asked to advise the suspect, presumably verbally. If we scroll up above, Jarnail Singh sends that to you. Susan, please see Dave Pardo email below. Can I have a word before response to Dave? Do you recall speaking to him about that?
I don't know,
No.
but I would have spoken to him about that, and I would have made the point that we've just discussed.
So is it right that some cases were discontinued or weren't proceeded with, but the Post Office was very clear that when it was doing so, it shouldn't tell people that it was because of the Horizon issue?
My position was that I didn't know, in the sense of absolutely know, that there were issues with Horizon at that stage, but that I did know we were going to undertake an independent review, and I didn't want to go ahead with cases that depended solely or in a significant way on the Horizon evidence.
Why would it need to be carefully worded, though?
I think it just needs to be sensibly worded, really.
The words he used are carefully worded, and carefully worded so as not to include an admission of Horizon integrity issues. You're copied into this email. Did you say, no, you should tell them that we've discontinued because we're looking into Horizon integrity issues?
I can't remember what I said.
Is it likely or unlikely that you had that kind of a conversation?
I would say it's more likely than not, but I really can't remember, I'm afraid.
So you think it's more likely than not that your response to receiving this email would have been, no, we can mention Horizon integrity issues when we discontinue the case?
I really can't remember.
Can we please look at POL 00141400? The next month, 11th of July. If we could scroll down to the bottom of page 2, please. Do you recall advice from a lawyer at Cartwright King called Harry Bowyer around this time relating to the case of Wiley?
So I didn't recall the advice, but obviously I've now seen it.
Do you recall advice being given that certain steps needed to be taken at this time in light of what had been discovered by Second Sight?
No, I don't think it was because of what had been discovered. I think it was the start of the Second Sight investigation,
Yes.
rather than what they discovered. So I think it was the mere fact that the investigation was going to go ahead.
And his advice was that certain steps needed to be taken by the Post Office before a prosecution should take
That's
place.
certainly how I understood reading it, recently, that's how I understood his advice.
The bottom email from Jarnail Singh, which you're copied into, says as follows, I agree, defence will approach to stay the prosecution until the review by Second Sight is completed will become increasingly common. Post Office view is that such an approach be resisted. He says, there's no reason, no legal or forensic ground to argue any defendants will not get a fair trial or abuse of process. There's no reason to justify the case being stayed. The fact that the review is being carried out is not an acknowledgement that there is an issue with Horizon, the system working properly, and is being used up and down the country when the system has been challenged in criminal courts, has been successfully defended. There is no mileage in this position, but is in fact superficial. Did you understand at that point in time that Jarnail Singh was saying that there shouldn't be a stay in cases simply because Second Sight were carrying out their review?
That's what I understood him to say, yes.
Yes. And if we scroll up, please, to the top of page 2. Hugh Flemington, so that's he was a lawyer in your team?
Yes.
Yes. He says, do we have counsel acting for the Post Office saying that we should agree to stay requests? And Jarnail Singh, copying you in, says, this was Mr. Bowyer's advice, which was forwarded to you on the 11th of July. And he says again in the top email, Hugh, Susan, are you happy with our stance, or do you want to make additions or amends? If we scroll up, please, there's a response at the bottom of page 1. From Mr. Flemington, he says, Jay, assume your recommendation hasn't changed and is still to keep fighting any such application. Issues appear to be comms brief needed to rebut the myths, clarity regarding Second Sight terms of reference, a plan/Bible of what information we're going to provide legal teams and courts if we have to fight applications to stay, plan to deal with disclosure requests. It seems as though in the summer of 2012, the Post Office perhaps wasn't going to proceed with new cases, but where there were ongoing existing cases, it was full steam ahead.
I think in this case, I think it eventually got stayed. I can't remember.
But in terms of your instructions as head of legal, there is a email chain here that queries whether to agree to stays, and it seems as though the feedback to Jarnal Singh is very much business as usual.
It certainly looks like that, yes.
Yes. Would you be surprised if we didn't find an email from yourself querying why they are continuing to prosecute?
Yes.
You'll be surprised if there wasn't an email
I
querying.
would be, well, it looks like we were having a conversation about it.
Yes.
And I think that would have been part of the conversation as to just how much reliance, and obviously it was the old Horizon system, not the new Horizon online system, how much reliance we were placing on Horizon evidence.
Did you agree or disagree with the sentiments that are being expressed in this email chain?
I can't remember. However, I do remember that we asked the comms to assist in a press release or something that could be used with the agents who represent us as to how to characterise the second site investigation.
So the response to a criminal prosecution and the potential of a stay was to draft a comms brief.
No, I'm just saying that that's what I remember happening at that time.
Yes. And do you remember expressing a view that the case of Wiley at this time should not proceed?
I cannot remember.
Looking at this chain that was copied to you, do you think it's likely or unlikely that you gave such an instruction?
I really can't remember.
I'm going to move on to look at the board's knowledge of these kinds of issues. We're going to move back.
Before you do, Mr. Blake, the last email on the screen is, as I read it at least, before a meeting has taken place, following those emails, if you see what I mean. I'm reading one for our 3:30 meeting, I think, as being these points are to be discussed, and that would be consistent with the timing of the email. Is there any note, so far as the inquiry knows, of the meeting which then followed?
So I'm not aware of a note. We can certainly look into it, but perhaps a question for Ms. Crichton is, does she recall such a meeting taking place?
Absolutely, thank you.
I'm afraid I don't know.
And do I take it that the email chain then peters out, so to speak?
It does, yes. If we could scroll up to the top of the page, please. There's a message from Jarnal Singh to Hugh Flemington saying that this case deals with the old Horizon system. I'm going to move on to knowledge of the board around this period. Can we please look at poll 00095587? We're moving back in time slightly to January of 2012. This is a significant litigation report. If we scroll down, we see your name there at the bottom, in January 2012. Did you implement significant litigation reports to the board? Was that your idea?
Yes, it was.
Do you recall when you implemented that? Approximately.
I had a conversation with Paula Venables and said that I felt that these should be included in the board packs. I think it might have been January 2012 because that was pre-independence. I think it might have been, yes.
So this may be the very first significant litigation report.
It might well be, yes.
If we scroll up, please, 1.1, it says, Post Office Ltd has received 4 letters before action from a firm acting for former sub-postmasters who were dismissed when discrepancies between their branch accounts and cash positions were discovered. Is that the Shoesmiths' claim at that stage?
I think it was, yes.
And if we look down 1.5, it says we may receive a large number of claims. similar claims, possibly between 55 and 150, according to press reports. It says, our strategy is to defend each claim robustly to deter future claims, and we will be responding to each in full. At present, we consider the legal claims to be weak and the damages claims to be inflated. We do not know what the ultimate value of these claims will be. Where it says our strategy, who was us?
I think in that context it was RMG civil litigation with input, I'm guessing, from me.
I mean, you drafted the significant litigation report.
I think they may well have drafted it and I checked it, or read it anyway.
So our strategy is whose strategy? Anyone in particular?
So, as I say, I think it was suggested by RM litigation team and accepted by me as an initial strategy. You know, as I've said previously, I was anxious to understand the Post Office's view and to bring more elements of commerciality to it.
We can have a look at the board meeting itself. Can we please look at poll 000211503? This is the board minutes of 12th of January. We see there that you are attending to deal with items number POLB 1206. Is that 214? So all items between 6 and 14?
I think so, yes.
We see there Mr. Young is also in attendance. But he's only there to deal with POLB 12/13. By this time, I think you were Legal and Compliance Director, part of the transition period, is that correct?
Yes.
Can we please turn to page 6? And there's discussion of the significant litigation report. So your evidence is that that report itself may have been drafted by the Royal Mail lawyers. If we scroll down, please. It seems as though, did you present that report to the board?
I'm not sure whether I presented it or not, but obviously Les Owen asked questions.
And I'll read as follows. It says, Les Owen, do you recall Les Owen? He was a non-executive director.
I do, yes.
Do you recall him? I think he was also a non-executive director at a number of other companies, including one that is technology-based.
I didn't know that, but I know he was on the RMG board.
And he ultimately, I think, became chairman of Royal Mail Group.
I didn't know that.
He asked for assurance that there was no substance to the claims brought by sub-postmasters which had featured in Private Eye. So there was a report in Private Eye. And it says, Susan Crichton explained that the sub-postmasters were challenging the integrity of the Horizon system. However, the system had been audited by RMG internal audit. With the reports reviewed by Deloitte, the audit was very positive. The business has also won every criminal prosecution in which it has used evidence based on the Horizon system's integrity. Susan Crichton suggested that she clear the audit report with the external lawyers, and if it is possible to give the report privileged status, it would be circulated to the board. What did you understand at this stage integrity to mean in respect of the Horizon system? It has used evidence based on the Horizon system integrity.
I would have understood it to be reliability and probity, I guess.
Do you recall the board probing the information that you gave them on this occasion?
No, I don't.
It does seem, at least from these board minutes, that you were, at that time, the channel passing information to the board relating to Horizon integrity.
I think what I was doing was responding to Les Owen's question about the sub-postmasters article in Private Eye, which is the one I refer to in my statement when I say that at the executive team meeting, I had asked Mike Young, because the letter had come from him, I think, how he had assured himself that it was appropriate to write in the terms to Private Eye. And in documents that have been recently disclosed, there's a draft from one of the RMG PR team, I think.
In terms of channels to the board, though, he was actually present and spoke to an entirely different matter. It seems as though you were the channel to the board in relation to the challenges brought by sub-postmasters relating to the integrity of the Horizon system.
Certainly in this case, yes.
Can we please look at poll 00103334? It's page 122 of that document, please. It may take a minute to come up because it's a large document. Thank you very much. Page 122. This is a paper that was provided to the board by Mike Young for the 15th of March board meeting, so a later board meeting addressing the Horizon system. I'm just going to read to you a little bit of background. He says in this paper, the recent incident on Horizon was the fourth significant service failure of this system in 9 months. If we scroll down, please. He says, as part of the move to Horizon Online, the contract was renegotiated and the architectural design changed in order to reduce Post Office's operating costs by £50 million per year, excluding VAT. One of the design changes which contributed significantly, circa £5.5 million a year, to the savings was moving to an active/passive data center arrangement. Consequently, the resilience is now housed in one data center, with the second data center primarily being used as a test environment, but available for disaster recovery if required. As a consequence of moving to the active/passive design, when hardware issues arise, they will result in network-wide service disruption. The previous active-passive data center arrangement would have prevented an impact to customers for the incidents of the 12th of December and the 1st of March, as the hardware would still have been working in the other data center. The level of risk associated with this design is being challenged in light of our future business strategy. And if we scroll down, please, over the page and over to the final page we see there, that's from Mike Young to the board. Now that's, as we can see, it's a very technical report relating to Horizon. Was any link drawn between those technical reports from the Chief Operating Officer and your reports about the challenges to the Horizon system by the board around this time? Were those strings drawn together at all?
I don't recollect that they were.
Mr. Young, as we know, left in 2012, and some of his responsibilities then fell to you.
The security team fell
Yes.
to me.
By the spring of 2012, were you personally beginning to draw the strings together relating to problems with Horizon and challenges to Horizon?
I was certainly, when we started to talk about an independent review, I was certainly very much in favour of that.
Can we please look at poll 001795524? So you said you were in favour of an independent review to look into those issues. We're now in March 2012, and Alwyn Lyons, the company secretary, sends you, Leslie Sewell, who at that time I think was the interim chief operating officer, Kevin Gilliland, who was the Network and Sales Director, a report called in Horizon Integrity, and we're going to see that is what we know as the Ismay report.
That's correct.
Can you assist us with why Alwyn Lyons in 2012 sent you a report that dated back to 2010?
My recollection is that I had not seen the report before, and as we were starting to think about or to look at commissioning an independent review, I think Alwyn must have remembered that it existed and got it from Rod Ismay.
Thank you. So you, as we've heard, were head of legal in 2010, but that's not a document that was shared with you at the time.
I have no recollection of it being shared with me at the time.
And these recipients, yourself, Leslie Sewell and Kevin Gilliland, were you the three, or perhaps together with Alwyn Lyons, looking into the issue of a possible review of the Horizon system?
I think it was more Leslie was leading on the development of a terms of reference for the review, and possibly Kevin Gilliland hadn't seen it before either.
Let's look at the Ismay report. It's POL 00179521. And it goes to Dave Smith, who was then the managing director, from Rod Ismay, head of product and branch accounting. You have the finance director there, and we have Mike Young, the chief technical and services officer. Rob Wilson, head of criminal law. Mandy Talbot is also a recipient. Does it strike you as odd that the head of criminal law, Mandy Talbot, and principal lawyer civil were recipients alongside the managing director, but you weren't a named recipient of that report?
I can't comment on that, but I didn't recall seeing it in 2010, certainly.
Does that distribution list strike you in any way as odd that you're not named there?
I suppose it was focusing on those people in the RMG team who dealt with Horizon issues, and possibly they had contributed to the report.
The report, I'm going to just read a few extracts from it. Post Office Ltd has over the years, and this is only in 2010, had to dismiss and prosecute a number of sub-postmasters and Crown staff following financial losses in branches. A small number of these have made counterclaims that they were not guilty of the charges made, but that the Horizon system was faulty. There's a section, if we scroll down, there's an executive summary there. If we turn to page 15, there's a section on known IT issues, including things like screen freezes. Page 17, please. There is a section on court decisions. I'll just read a few passages from this section. It says, there have been cases when taken to court by the Post Office where the defence has claimed that the accounting system Horizon was at fault and that there were incidents such as ghost transactions or electrical supply issues which have corrupted the Horizon records. But with two notable exceptions, the Post Office has been able to rebut these assertions by ensuring a focus on the facts of the Horizon transaction logs and a request for the defence to be specific about what transactions they consider to be ghost and why. Are you able to assist us with the two notable exceptions, what they may have been?
Was the Cleverley's case one of those? No, I'm not actually. No, I'm.
You're wondering whether it was the Cleverley's case?
Cleverley's case.
That case is actually mentioned further down, and we'll come to that.
Right, okay.
You're not able to assist with two notable exceptions?
No.
Do you recall asking what the two notable exceptions were?
No, I don't.
If we scroll down, please, there are three landmark cases which feature in the arena of challenges to Horizon. The first we see there, the Cleveleys, sub-postmistress dismissed in 2001, soon after Horizon was introduced. The defence produced a report which showed how Horizon could have caused an error, and the Post Office did not have the audit transaction logs to refute the claim. The Post Office settled out of court, it says there, for £187,000, but subsequently improved the retention of audit transaction logs. This case would not have the same outcome today because of improved liaison between Fujitsu and the Post Office and availability of logs. It then goes on to the Castleton case. Lee Castleton claimed that Horizon was faulty and found other sub-postmasters to back him. However, the Post Office presented the audit transaction logs to his solicitor, who promptly advised Castleton there was no basis to his case. Castleton sacked him, lost the case, was found liable for £300,000 and went bankrupt. The judge decided there was no flaw in the Horizon system and said the logic of the system is correct. The conclusion is inescapable that the Horizon system is working properly in all material aspects. If we scroll down, there's the case of Mr. Darlington at Alderley Edge as well. Did this cause you any concern when you read it, that there's mention there of the history of cases relating to challenges to Horizon? In this case, we have civil cases, so not outside of your area of expertise. Were you concerned on reading
I
about
think it fed into my view of the need to do an independent investigation. I can't remember specifically reading this in 2012, but I think it just sort of further confirmed that we needed to try and resolve the issue, or understand what the issue was, perhaps I should say.
We've seen this morning the continuation of prosecutions relating to Horizon. Doesn't it need a little bit more than just to think about an internal or an independent review of some sort?
I think at that time that was my understanding, that some independent review would assist the business in deciding or understanding what was going on in this situation.
Thinking about it now, though, do you think that there was a lack of urgency?
Absolutely, with hindsight, I feel, and I started off by saying how sorry I was. I'm also sorry that this took such a long time to be resolved on my watch.
If we please go over to page 19, there's reference there to independent review and audit angles, and it's ruled out in 2010. It says the Post Office has actively considered the merits of an independent review. It says further down, Ernst & Young and Deloitte are both aware of the issue from the media, and we've discussed the pros and cons of reports with them. Both would propose significant caveats and would have limits on their ability to stand in court. Therefore, we have not pursued this further. If we scroll down, please. It's also important to be crystal clear about any review if one were commissioned. Any investigation would need to be disclosed in court. Although we would be doing the review to comfort others, any perception that the Post Office doubts its own systems would mean that all criminal prosecutions would have to be stayed. It would also beg a question for the Court of Appeal over past prosecutions and imprisonment. We've looked this morning at the question of stays and the decision taken to press on with existing cases. Did receiving this in 2012 cause you to rethink whether that was the appropriate course of action?
It certainly should have done, yes.
On receiving this in 2012, did you speak to anybody within the business about it?
I can't remember.
I'm going to move on now to the selection of second sight. So that might be an appropriate moment to take our first break of the day. I think the proposal is for it to be a 10-minute break.
Yes, that's right. So
Take us to 11:05.
11:05. Thank you very much, Mr. Blake.
Thank you very much. Thank you, Mrs. Crichton. We're going to move on now to the selection of Second Sight as the independent reviewer. Can we please look at poll 00002000, please? Paragraph 107 and also 134 of your witness statement, you say that Deloitte prepared a proposal for an independent review at around May 2012, and I think this is the proposal document.
Yes, I was pleased it was disclosed because I thought I remembered it, but I hadn't received a copy of it.
And if we look at page 4, please, Deloitte, in what they called Project Spire, set out a proposed approach to a review. And they said, step 1, understand processes, data flows, and key risks. Fundamental to the assessment of processing integrity is the understanding of the data flows, processes, and key risks in the end-to-end process. They say a bit further down, they say, using our data governance framework as best practice benchmarking tool, we perform a current state analysis on the organisation, interviewing key personnel, examining documentation, and reviewing systems. And at step 3, sample to confirm data accuracy and integrity. They refer to their data testing using a substantive testing technique. Did you understand Deloitte to be proposing quite a technical look at the Horizon system?
To the extent that I remember it, I remember thinking that this wasn't looking at it from the point of view of people operating the system, but rather the system as a whole.
Yes. Perhaps if we go back to poll 00137-248, please, the note that was the meeting of the preparation meeting for the Lord Arbuthnot and Oliver Letwin meeting, and that was also in May of that year. Can we please look at page 3? There's a reference to Deloitte, and it says as follows: why are we considering Deloitte to perform the audit? And it says KPMG are excluded as they are Fujitsu's auditor, Ernst & Young are excluded as their Post Office's auditor, etc. And it then says Deloitte are Post Office's supplier, are on Post Office's supplier shortlist and have proven experience in this area. And then it says the audit costs, these are potential questions that could be asked. The audit could cost in the region of £250,000 to £500,000. Why so expensive? And the answer is the audit envisioned is a thorough end-to-end review of processes, systems, and data, which not only could reveal potential improvements, but could be used as an assurance for future court cases. The cost is as a result and thoroughness of the audit and the expertise required. An alternative reduced scope audit could also be considered. So was that your understanding as at May 2012 that there was going to be potentially a thorough end-to-end review carried out by Deloitte?
My understanding was that that was what was suggested.
By Deloitte? Or by
Leslie and Deloitte. So she had led on the commissioning and conversations with Deloitte, although I have a vague recollection of going to a meeting with Deloitte to help scope the project, but really Leslie was leading on that, Leslie Sewell.
Yes, thank you. Can we please look at poll 00006484? We're now in June of 2012, and there is a meeting with Richard Morgan QC, 12th of June, at his chambers. And you are one of the people attending. Can you recall the purpose of this meeting?
So I think this was after Alice Perkins had asked me to find a forensic accountant of a different type, or maybe it was just in respect of the independent review. But I think I'd asked for help in drafting the terms of reference from Bond Pierce.
And the note says as follows: it was recognised that an impasse had been reached in relation to the Horizon litigation which Poll is seeking to address. Just pausing there, was that at that stage Shoesmiths, or was that something else?
Sorry?
What was the Horizon litigation at that stage?
Oh, that was the Shoesmiths. Litigation, yes.
The question is, what is the best way of breaking that impasse? The proposal to instruct an independent expert to prepare a report on the Horizon system is the highest risk response to the issue. What will it achieve? It will not be able to address any of the civil/criminal cases dealt with under old Horizon. Will it seek to review particular cases? If so, which ones? Are you able to assist us with who that is a note of? Is that of counsel or of an attendee?
I think it must be an attendee.
Whatever the findings of the expert report, it will not resolve the problem. The Post Office will be damned if they do and damned if they don't. Do you recall that being said by somebody?
I don't, but it's presumably an accurate recording of what was said at the meeting.
And again, are you able to assist us with whether that is... it says at the top, if we have a look at the top of the page, it says summary of conference.
I think that might have been counsel.
Thank you. If we scroll down, please, it then says, the Post Office will always have this problem. Some people will never trust computers and will always believe they have an inherent problem. A less risky approach is to agree to take relevant MPs privately through particular cases in which they are interested. Can you recall the discussion in that conference? Was this the general view of the attendees? Was this just the advice of counsel?
It was certainly the advice of counsel. I do recall that. I also recall what is described in the note as a less risky approach was the current approach that was taken by Post Office. As I've explained earlier in my evidence, they would take the cases where there are complaints and work those through.
Did you agree with the advice that was being given or the information that's recorded here?
I felt, given my conversations with Alice Perkins, that we had to move on from this position, which was why, and I think it was by this stage, she had asked me to find a forensic accountant who might be able to help in a different way to that described in the Deloitte proposal.
Can you just assist us? You referred to conversations with Alice Perkins. Can you just summarise that for us?
My memory is that we'd had a meeting where the Deloitte proposal was explained, and I think it was either that meeting or shortly thereafter. She had asked me, and I included it in my witness statement, if I knew of a forensic accountant who might be able to help. And she had, a sort of, as I described, a shopping list. So shouldn't be one of the big four, had to be somebody who would be able to carry out the review, would be somebody who would be credible to the MPs, James Arbuthnot, Justice for Sub-Postmasters, and would be able to have conversation with Sub-Postmasters.
And why not one of the big four?
So I'm not entirely clear on that, but I think it was because what the chair didn't want was something along the Deloitte spec, which was very much process. My retrospective interpretation of that is that she did want to take into account the sub-postmaster's experience in dealing with the system and also to focus on the MP's cases. And obviously the Deloitte report might have gone some way to that, but it wouldn't have focused on the MP's cases.
Did the advice from counsel at this meeting influence the decision as to whether Deloitte was or was not chosen?
No, I don't think so.
You've said in your witness statement, paragraph 152, that can come down, thank you, that from my perspective, the investigation was undertaken precisely to assess whether there were issues with the Horizon system. You say from my perspective, were there different perspectives on that at this time?
I'm not sure there were at this time, but from my perspective, at the time it was kicked off, started, it was to take the cases put forward by the MPs and for Second Sight to work those cases through using their specialist expertise, as I think I've described in the statement, in various ways.
We're going to now look at a proposal from Second Sight in June 2012. Can we please have a look at poll 0009656? This is a report or a proposal that has been produced by Second Sight to carry out an independent review of past fraud and theft cases in order to determine whether the facts support the business findings and the charges brought against individuals. Can we please just scroll down the page over to the next page? So the proposal, Second Sight has been invited to carry out a review of a yet-to-be-determined number of closed and possibly some still open fraud and theft cases. So as you've said, the proposal there is to look specifically at the cases rather than the system as a whole, potentially.
Correct.
We do, however, if we scroll down, we can see that this proposal has been drafted by Mr. Warmington. That's on page 3, thank you, 1st of June 2012. Can we please turn to page 5? It does seem that, at least to some extent, under the heading of case review approach, there will be, if we look at the right-hand side, 4th paragraph, 4th bullet down, study and selectively test the Horizon system in order to find any black hole, program bug, etc. that might have caused mysterious shortages. So it did seem as though part of Second Sight's proposal was going to be to test the Horizon system.
But I think it was to test it in the context of those cases, not more generally.
Thank you.
That was my understanding.
Can we please look at poll 00180209? And if we scroll down to the very bottom, so it's the second page, the bottom of an email chain. And so at the very bottom of page 2, we have Ron Warmington sending you and Simon Baker the proposal. He says, as promised, here is our proposal for the case review. And if we scroll up, we have Simon Baker responding to yourself and also copying in, addressing it to Leslie Sewell as well. And he says, attached is Ron's proposal. My view is that we make it clear to Alice/Paula the distinction between the work Ron is proposing, an independent review of past cases, and the Horizon forensic audit, the Deloitte proposal, and put it on the agenda to discuss tomorrow. Now, it seems as though the suggestion is that there are potentially going to be two different investigations. One is the Second Sight independent review of past cases, and the other is a forensic audit carried out by somebody like Deloitte. Is that understanding correct?
I can't remember. I just know that they were quite different reviews, and I think we made that clear as part of the meeting with Alice Perkins and Paula Venables.
And if we scroll up, please, we have an email from yourself saying, in the meantime, Alice has asked for a terms of reference for the work that Ron et al. Are going to do. And if we scroll up, Simon Baker responds saying at the bottom, I'm also hoping to have a proposal from Deloitte sometime this evening, which I'll also bring to the meeting tomorrow. So it looks as though there's going to be a meeting on the 7th of June relating to the various proposals. Can we please turn to poll 002333736. This is a timeline of the mediation scheme, and it's only one part on page 3 that I'd like to take you to. It logs various events over various dates, and if we could look at the 7th of June 2012, it says in this document, a meeting is held between Paula Venables, Alice Perkins, Susan Crichton, Alwyn Lyons and Simon Baker, where the Deloitte and Second Sight proposals are discussed. Second Sight is chosen as the preferred supplier. So it seems by the 7th of June, it wasn't an either, it was an either-or decision between Deloitte and Second Sight, not a proposal to have both types of review, and Second Sight win the contract. Is that correct?
I can't recollect that we were going to do both of them, but I do recollect that Alice Perkins' objective was to satisfy the MPs in regard to their constituents. So obviously the Second Sight review would be more likely to do that than the Deloitte's review would be.
Can you recall that meeting, what was discussed at that meeting?
I can't, no. All I can recall is the information I've seen in the emails.
You refer in particular to Alice Perkins. Was she a particular driving force at this meeting?
Yes, she was. Well, I think at the meeting, I can't remember, but I know that she was very much engaged with the matter of trying to resolve the MP's queries.
So the focus for her was resolving the issues for the members of Parliament and their constituents.
That's my recollection, yes.
Do you recall the view of Paula Venables at this time?
No, I don't think I do, but I suspect it would have probably been the same.
And what was your view at this time?
I felt very strongly we needed to move forward. And if that was getting Second Sight to do a review of the MP's cases, I felt that would help us understand what was going on.
But it wouldn't, of course, carry out some sort of end-to-end technical review of the type that was proposed by Deloitte.
No, it wouldn't.
So when you say move things forward, do you mean bring to a swift conclusion the issue?
I think I was trying, it's difficult to remember, it's so long ago, but I was trying to ensure that the cases raised by the MPs were properly reviewed, and the Deloitte's proposal would not do that.
Well, they would help you to understand the underlying problems, though, wouldn't it?
It was a very technical audit, and the proposal was pretty technical. I wasn't actually sure, because I think what we were looking at in terms of what the postmasters were dealing with was the system possibly not performing as it ought to, and I wasn't sure that the Deloitte's report, in hindsight, would have given us that insight.
It's a very technical system, though, isn't it?
It is.
Didn't a technical system need a technical report?
So I'm struggling a bit because I'm trying to find the right words. What I wanted to do was to look at it from the sub-postmaster's point of view, because yes, it's a technical system, but as having worked in financial services for a long time, my background was technical systems have to be made for work for the people who use them. So it's how does this then work to support the sub-postmasters in their offices?
Thank you, that can come down. In terms of Second Sight, Ms Venables has said in her witness statement that you knew Ron Warmington from earlier in your career and socially at a local tennis club. She says, although she understood that you weren't a close acquaintance. Are you able to assist us with...
So I'd worked with Ron Warmington at GE, and I certainly didn't know him outside work.
So the suggestion that you knew him socially at a tennis club, that's wrong?
No.
How well did you know Mr Warmington?
He worked, so I was part of the EMEA team at GE Consumer Finance. He was actually part of the international team, I think, frauds and investigations. So he and I had worked closely on a couple of investigations that he'd done with me, one in Switzerland and one from memory in Czech. And I think he also provided advice on fraud prevention, but that would more probably have been for the risk team at General Electric rather than for me.
we saw there in the proposal, there was at least a proposal to look at some technical aspects insofar as they related to the individual cases.
Yeah.
Was that discussed at all once Second Sight had been taken on as to how their technical investigation would take place?
Certainly when they came into the office, yes, I think it was, because when they came into the office, I gave them or showed them the files that we had managed to obtain, and I then arranged for them to have a briefing on Horizon. Again, from memory, they did Horizon training. Simon Baker, who was the project lead, was part of Leslie Sewell's IT and change team, so he provided the link into the IT system. And it was Ian Henderson's particular area of expertise. So I certainly thought that's what part of what they would do.
One of the first areas of discussion is whether those who had been convicted should be included in Second Sight's review. And I think you said that at that stage there was a concern about reopening prosecutions that had concluded. Is that right?
That is correct, yes.
Can we please look at poll 001800234? It's an email from Simon Baker to yourself of the 7th of June 2012. He says, in speaking with Mike this afternoon, we wondered if it's worth making a distinction in the terms of reference between cases that have been prosecuted and those that haven't. For those cases that have already been through the legal system, we don't want to be seen as reopening the cases. Instead, we want to be in a position, we want to position those as a review of the existing evidence to enable an understanding of the allegations and facts in regards to Horizon. For those that haven't been prosecuted, we can position as a full independent investigation. So was part of your thinking at that time also that those who hadn't been prosecuted would get a full independent investigation, but those who had been prosecuted would get something a little less than that?
I think it probably was, yes, but I think, as again I go on to say in my witness statement, that at least two cases where prosecution had ensued were included in the Second Sight review.
Yes, were ultimately included.
Correct. Perhaps
we can see an email from yourself of the same date to Alice Perkins and Paula Vennells. That's poll 001054772. And you say, in addition, and following a review of the cases listed, which I had not seen this before, I've been giving some further thought to our position, particularly in respect to the cases where we have criminally prosecuted the sub-postmaster or postmistress. In those cases, I do not think that we want to be seen as reopening the cases, but rather position this as a review of existing evidence to enable an understanding of the outstanding concerns and the facts insofar as they concern the Horizon system. For those who have not been prosecuted, we can offer a full independent investigation. So that's very much echoing the views of Simon Baker in that previous email.
Correct.
Why would it be a problem if problems with Horizon were identified in respect of those who had been convicted?
I suppose what I was thinking was that we should then proceed, and forgive me, I'm lamentably unqualified in the criminal piece of this, but what I was concerned was they had gone through the courts and they had been convicted, and I thought we shouldn't reopen that.
But if there was new evidence that showed that that conviction had been unfair,
yes.
Wasn't that something that positively should be investigated?
Yes, I agree with you. It should have been.
So
and it was, actually.
But as at June 2012, it was your position that they shouldn't be. That was a mistake?
I think I was sorry, I apologise.
Was that a mistake on your part?
I think it was, yes.
Can we please look at poll 000096606? This is an email exchange with Alice Perkins. If we could look at the bottom email, please. 9th of June 2012, from Alice Perkins. And she says as follows. She says, I am clear that we should include all the MP's cases, irrespective of whether they have been decided in court. If we try to draw a distinction here, we'll be accused of picking cases to suit ourselves and being vulnerable to ones we omit. We'll have a row about that instead of moving the issue on. On reflection, I don't buy the argument that we would somehow undermine the court process by doing this. There are plenty of ways in which people go over ground which has been settled in court, and if there weren't, no one would ever be able to get a conviction overturned. And if, which we don't believe, there were new evidence in a case which had been decided, we would want to do and be seen to do the right thing by that. She says, I'm sorry to be bothering you with this on a Saturday, but time is against us, especially as Paula is seeing James Arbuthnot on Monday afternoon, and I feel strongly about this. Scrolling up, Paula Venables responds, copies you in, and she says, Alice, if Susan doesn't get back to you, I'm around, so call me on the mobile. I wasn't party to part of this discussion, as it was when I was in the Eagle meeting, but we can talk and I can pick up with Susan on Monday. And then we see an email from Alwyn Lyons summarising the position to Paula. And she says, Paula, in case Susan doesn't pick this up as she's in Berlin and therefore, and before you speak to Alice, the issue that came to light with a list of MP's cases was that they included the, I think that's meant to be Misra case. You'll remember the case and the publicity. She went to prison and had her baby whilst in there. The husband got publicity through radio and press. Susan's anxiety, and she raised this at the meeting with Alice before you joined, was whether now contacting her to tell her we review the case would be a red rag to a bull. Alice feels this is the business pushing back unnecessarily, and she feels this has happened throughout the process, and she's having to keep pushing this. So just looking at the Misra case, it seems as though you were concerned at that time about the publicity that had been raised by her conviction, and that now telling her that you were going to review her case and look into whether or not there weren't issues with Horizon would be a red rag to a bull. Was that your position at that time?
I was very concerned about the situation. I understood what had happened in the Misra case, which was clearly very concerning, and I didn't want to reopen it unless we had good reason to believe that there was an issue there, but it was included on the list of cases to be reviewed.
It was ultimately included, but it seems as that, and we see at the bottom Alice Perkins expressing quite a strong view that these kinds of cases should be included.
Yeah.
But it seems as though you have expressed a particularly strong view in respect of the Seema Misra case, that because it was a highly publicised case, it wasn't one that should be looked into.
My other concern around it was that it effectively would, dilute the publicity with regard to the other cases that were being looked at.
Because somebody who was put in prison and had a baby there would get more publicity than other cases?
I think what I was concerned about was that if we were going to reopen this case, well, not reopen it, but investigate this case, it must be done appropriately, and we must then be able to move forward with the conclusion. So if, and I understand now around the disclosure of information and the importance of that.
And it might be that Seema Misra's case got a lot of publicity because she was put in a terrible situation, and
Absolutely.
looking into the issues that she raised in her trial and to see whether there was anything in it might precisely have been the very thing to do at that time.
I agree.
And why didn't you agree at the time?
I was too short-sighted, maybe.
It looks as though, as at the 9th of June 2012, you wanted a narrow review, not looking at decided cases. And at this time, we're going to go on to talk about what happens later, but at this time, June 2012, Alice Perkins thought that it should be wider, all MPs' cases. She refers to being seen to do the right thing. The business was pushing back, it seems. Do you agree with that characterisation of the difference in those two positions?
Probably, yes. Yeah.
I'm going to move on to 2013. Can we please look at poll 000595567? Can we start on page 2? Second Sight have been carrying out their investigation for some time now by January 2013. Ron Warmington emails Simon Baker, Ian Henderson and yourself and others. He says, "Hello Rod, all. As just mentioned, I'm afraid we now have to seek information on the time it has taken to notify the sub-postmasters in our sample about transaction corrections. The issue here is whether sub-postmasters have been able to get to the bottom of a transaction correction in the event that they've been unable to print out or even to view on screen the underlying transactions that went through, and in some cases were also reversed on the day of the challenged transaction. What we need to establish is how many of the transaction corrections that were raised in the 32 cases that we now have in our sample were notified to the sub-postmasters after 42 days had expired. So in essence, how many sub-postmasters were notified too late about transaction corrections. If we scroll up, we can see an email from yourself to Alban Lyons, and you say, but this is not Horizon. How do we box this off? So by early 2013, were you trying to confine the areas that Second Sight were looking into?
I think I was just trying to understand what it was.
But you weren't trying to understand. You weren't saying, what is this? You were saying, how do we box this off?
Well, how do we resolve the issue? So with transaction corrections.
Does box off mean resolve the issue, or does box off mean prevent the issue from being looked into?
So I think in the context there, I wanted to understand what the issue was. Because
but it doesn't, I mean, you're not asking there what the issue is. You're saying, effectively, how do we stop this being looked into, aren't you?
No, I don't think so. I think if you go further down, my recollection is from Ron's email, that he talks about the delay in transaction corrections coming through and the difficulty that sub-postmasters have in reconciling those transaction corrections because of the delay that's coming through.
Yes.
So, I think I just wanted to understand what the issue was.
The suggestion from your email seems to be that isn't fairly and squarely within the issue of the Horizon system. That's to do with transaction corrections, and therefore that shouldn't be something that Second Sight are looking into.
No,
Am I unfair in that suggestion?
I think so, because what I was trying to say is, how does this all fit together? Because transaction corrections come from a different system, didn't they? I thought, I didn't know.
So your expression, box this off, it is your evidence to the inquiry that is in fact a request to look into something more rather than not look into something.
That's what I think, yes, that's what my recollection would be.
Do you think that's a reasonable interpretation of those words?
No, I don't.
What do you mean by that?
So I think it could be read in how do I box this off. I think what I was trying to say is, how do these fit together with Horizon? So if they're not in the Horizon system, how does it all fit together?
It's answered by Simon Baker. If we scroll up, please. Sorry, actually, if we go to the top email, it's answered by Alban Lyons. And she says as follows. She says, so you are right, not a Horizon issue, but Ron's point is that if transaction corrections come late and there was a Horizon issue, sub-postmasters have no chance to look at the evidence.
Yeah.
So she's making clear to you there that, in fact, although it's not technically an issue with the Horizon system, it's an issue with your processes, which means that sub-postmasters wouldn't, in fact, have a chance to look at the evidence because they wouldn't know whether their transaction correction is being accepted or not.
Yes.
Do you think at that time you and others within the business were genuinely interested in Second Sight investigating those kinds of issues?
Yes, I do.
Because what appears to be happening is that we've gone from a situation where we have Second Sight and Deloitte making different proposals. One included a highly technical review of the system. Second Sight winning the contract, to trying to narrow the scope. For example, we saw your email about not including those who are convicted of criminal offences. And here, it looks as though a reading of that email correspondence is that it's trying to narrow the scope further, to confine them simply to the Horizon system itself. Do you agree with that or not agree with that?
No, I mean, I think the intention, and certainly from the beginning, was that they should look at the MP's cases, and in order to do that, they needed to have the ability to go, I mean, as their proposal said, to go outside of Horizon, and as their definition in the interim report says, that it was much broader than Horizon in terms of training, support, how postmasters were more generally dealt with.
So am I to understand that there wasn't an attempt at this stage by the Post Office to confine the scope of Second Sight's review?
That's my recollection. My recollection was that we wanted to have the review done on the cases raised by the MPs.
Can we please look at poll 001448482? 22nd of April 2013, email from Simon Baker to yourself, Alwyn Lyons and Leslie Sewell. This refers to a letter from James Arbuthnot to Alan Bates, and he says, the key points to me in the letter from James Arbuthnot to Alan Bates are his suggestion that Second Sight focus their efforts on 2 best MP cases. As a result, even if preliminary by the summer, he doesn't respond to Alan Bates's request to focus the investigation on systemic failures. He says Alan Bates's request for Post Office to continue to fund K&L is for Alan Bates to take up at the Post Office. And then he says this gives us the opportunity to really contain the scope of the investigation. Now that is inconsistent with the evidence that you've just given on containing the scope of the investigation. Why would it be that in April 2013, Simon Baker felt able to say to you that there was scope to really contain the scope of the investigation?
I think we were finding from a practical point of view that investigation was taking a lot longer than we had anticipated, that we weren't getting through the cases, or Second Sight wasn't able to get through the cases in the sense, in a timing sense that we had hoped, and that we needed to get to some conclusion on some of the cases. So I mean, it's really down to his recommendation, and also what we needed to have in terms of updating James Arbuthnot and what had to be included in the report to go. And I can't remember when we agreed to do it, but the report that had to go back to James Arbuthnot on the MPs before the summer recess.
Isn't the words that are highlighted on screen there entirely consistent with the email that I took you to from yourself saying that you needed to box off an issue? Don't they both suggest together that in early 2013 the Post Office was trying to reduce the scope of Second Sight or contain the scope of Second Sight's investigation?
It wasn't my intention to restrain or contain the scope, but I was concerned that we needed to get to some determination on the MP's cases, and I can't remember when they developed the concept of the spot reviews, because that was sort of, again, was trying to move the investigation forward.
Do the words here make you revisit the words that we saw just before about boxing off the investigation, or is it still your evidence that that wasn't trying to reduce the scope of the investigation.
I don't think I was. I think I was trying to understand how it all fitted together.
And he says as follows: my recommendation is that we take advantage of this and draft a letter from Paula/Alice to James where we suggest the following. 1, we're concerned about the overrun of cost and time of the investigation, noting it's been running for a year and to date no evidence of systemic failures have been found. 2, to move forward, we suggest that Second Sight complete 2 in-depth MPs cases, selecting the ones that they feel indicate systemic problems. Post Office respond to the 4 spot reviews. We meet with James Arbuthnot in June. Set the expectation that when we meet in June, unless there is strong evidence of any system failures, we will close the investigation at that point. I mean, it certainly seems as though in early 2013, the line from the Post Office is that progress needs to be made. We're concerned about the cost and the time, and if there isn't evidence by the summer, we should close the investigation. Was that a view that you shared?
No, I understood from the chair that we needed to review the MP's cases, and we were going to do that through the Second Sight process. I do agree that we were concerned about the overrun of cost and time, and we were concerned about the efficiency of the process going forward. And I think actually that was a concern shared by Second Sight.
As the year progressed, was the Post Office increasingly concerned about the way that the Second Sight were finding issues with Horizon?
I don't know about more generally, but I still felt it was important for them to review the MP's cases, and to the extent I was frustrated, it was because of what I felt was a lack of progress. And I'd stress that, in the beginning, we were late and slow in getting them documented implementation, and we had to develop a system to assist them, so the scanning system we put in place.
Were you not increasingly concerned about the potential findings of Second Sight?
No, it was an independent report, and they had. So my attitude was with Second Sight that I tried to make sure they got the information they asked for in a timely fashion, and that they were assisted in the way that we could assist them in coming to their conclusions. But I do agree there was concern about the level of cost and the level of resource it was taking up.
Can we please see poll 001899210? We're in June now, so the time at which progress had to be made or it would be shut down. Can we scroll down to the bottom, please? We have an email from yourself to Ron Warmington saying, hi from sunny Croatia. Given the short timescales, wondering how things were going with the report. Now, I think you were on holiday at that time. Had you been tasked by somebody to chase the Second Sight report?
No, I don't recollect that, no.
If we have a look at the response from Mr. Warmington, he says, wow, Croatia, are you trying to get far away that the shockwave won't impact? Were you aware at that stage of a potential shockwave arising from Second Sight's report?
No, I don't think so. I mean, we had been through the sort of... No, I don't think I was. It was an independent report, and it had to be allowed to be an independent report.
He says, seriously, it's all getting a bit heated, not least because of the need to disclose those 2 Horizon defects. Gareth Jenkins called them bugs in his report that impacted 77 sub-post offices and resulted in some sub-postmasters being asked to make good an incorrect amount, wording from Gareth's report. The problem is that in answer to James's question, which is bound to ask, have you, Second Sight, found any instances of a defect in Horizon that led to a shortage for which any sub-postmaster was held accountable? The answer might be no, but in any event, Post Office has disclosed 2 software defects that did have that effect, albeit the Post Office dealt with them very properly and wrote off the differences that had arisen. That correction process looks to have taken over a year in regard to the differences arising from one of the defects, however. And he continues and says, we're also trying to bottom out the Rudkin matter, and it looks as though it will go to the wire. Is that the issue of remote access, or what we refer to as
The Rudkin matter, yes, I think it is.
He says there, he refers to Horizon defects, and he says Gareth Jenkins calls them bugs in his report. Do you recall there being an issue within the Post Office about referring to bugs and trying to change the wording?
Not from my point of view, no. I mean, I would tend to use the word defects in any event because I think bugs is just a bit slang.
Pardon?
I just think using the word bugs is sort of a bit not precise, so I would use the word defects.
I mean, Gareth Jenkins was a Fujitsu engineer.
He
who
was, yes.
Highly knowledgeable about the Horizon system. If he called them bugs, what's wrong with calling them bugs?
Just a different style.
Just a different style. Can we please look at poll 003800985? Because it seems that by July of 2013, there is discussion within the business at the highest levels about changing the language that's used about these bugs. We see here 2nd of July, if we have a look down at the bottom email, it looks as though the question has been posed, what is a non-emotive word for computer bugs, glitches, defects that happen as a matter of course? And Paula Venels emails as follows. She says, my engineer/computer literate husband sent the following reply to that question. And the answer is exception or anomaly. You can also say conditional exception/anomaly, which only manifests itself under unforeseen circumstances. And then there are 2 kisses. She says, does that help? The kisses were for her, she thinks. And she says, thank you for the work. If we look up to the response from Mark Davis, so Mark Davis was the communications head at the Post Office at the time. Is that right?
As I recall, yes.
To her, to Paula Venels, you're copied in, and he says, I like exception very much, very helpful. Do you recall, I know that you said that you had issue with the word bugs because it seemed to you to be slang despite being used by Gareth Jenkins, but can you recall at the same time, at the very top of the business, discussion about using less emotive language for what was occurring?
I'm sorry, I really don't recall, but there was. I really don't recall that email.
You don't recall that there was discussion about using less emotive language?
I don't think so, no.
Can we please look at poll 001900361? It seems around the same time, the next day, there is discussion with lawyers, CMS, to look at the legal implications of Second Sight's interim report for potentially defamatory content. Do you recall around exactly that time the Post Office seeking to challenge potentially Second Sight's interim report?
I didn't recall this. It came through in the last lot of disclosures. I think it was probably, well, I'm assuming it's probably as a request from the comms team.
If we have a look at poll 001900619, it does seem that you were involved in requesting such advice? Poll 00190-619. Thank you. Can we have a look at the penultimate page, please? Susan Barty, a partner at CMS Cameron McKenna, says, "Dear Susan and Hugh, you've asked for my opinion as to whether we can obtain an injunction in relation to the Second Sight report. Do you recall seeking legal advice trying to injunct the Second Sight interim report?"
I don't know. I really don't recall that.
Do you recall at least that, as at this time where discussions are being had as to references to bugs and how to describe them, there were also attempts to prevent Second Sight's report from being released?
No, I don't recall that.
Can we please turn now to poll 00145-100, and we're back on the issue of description of bugs. Over to the second page, please. We have a speaking note. It's an email from Martin Edwards. If we scroll down, he says, "Alice, Paula, with many thanks to Susan, Alwyn, Mark, and everyone else involved, here's the briefing note for the meeting with James Arbuthnot. Do you recall in July, so exactly the same day, in fact, as the injunction against Second Sight's report is being discussed, do you recall being part of a group who drafted a briefing note for the meeting with James Arbuthnot?"
I don't recall it, no, but obviously I was.
If we scroll down, please. Briefing note with James Arbuthnot, 3rd of July 2013. Can we scroll down? We see over the page the beginning of speaking notes. And over to page 4, please. It says as follows. From what we've been told by Second Sight so far, there is no evidence in the interim report to support any suggestion of systemic failures with the Horizon system. This is based on the 4 best cases from all those under review. If this is the case, important that point is communicated early, given some of the original allegations about the system. Otherwise, computer and agent confidence in the integrity of the system could be fundamentally underlined. And then it says as follows: "This is not to belittle the importance of the overall user experience for sub-postmasters. It is essential that we continue to improve our wider systems of support and training for agents, and we're grateful for many of the additional insights generated by this investigation to date. Many of these processes are historical. Process issues are historical and have already been rectified through improved guidance to staff and training for sub-postmasters, but where further changes need to be made, we will absolutely act on them." Do you recall at that stage a shift to the focus being on the wider Horizon system and not on the computer system itself? So to include, for example, the support that's being provided to sub-postmasters.
So when the Second Sight report or investigation was started, it was the case that they were going to look at the broader Horizon issues in terms of support for sub-postmasters, help desk, MBC. So a much broader investigation than just the Horizon system as it related to sub-postmasters and the MP's cases. So I think that's consistent with the commentary here. I also think that because of the delays in the report, we were trying to say, they've looked at their 4 best cases and currently they don't have evidence to support the suggestion of systemic failures.
Can we please move to page 6 of this briefing note? And it's here that I want to focus before we take our second break. There is a heading, System Exceptions. And it says as follows: "We know of 2 system exceptions, in brackets, anomalies, under the current Horizon system where sub-postmasters' accounts have been affected. and both were voluntarily communicated to Second Sight, although not directly related to cases under review. Key point to note is that in both cases, our processes picked up these issues, appropriate remedial action has been taken, and they did not lead to any disciplinary action against the affected sub-postmaster. Absolutely no reason to believe this means there are other undiscovered issues. If we scroll down, please, it then gives further detail of the two cases if required. And there's reference there, the 62 branches exception. Can you see everything's now being called an exception rather than a bug? We know this as the receipts and payments mismatch bug. I think Gareth Jenkins knows this as the receipts and payments mismatch bug, but it's now being called the 62 branches exception. If we scroll down, the 14 branches exception. I mean, are we to understand here that words that were suggested by Paula Venables' husband have now made their way into the terminology that's being used by the business?
That's certainly what it looks like.
And you were, it seems, part of the group that drafted this briefing notes. So do you really not have any recollection of the word exception now being used instead of bug?
No, I don't. I would have given input around the Second Sight report.
It's absolutely Orwellian, isn't it? The use of the word exception now instead of bug, changing the language within the company, crafting a briefing that now refers to exception. Did you not take responsibility for that briefing, given that you were one of the people drafting it?
If I had solely drafted it, it would have been my work, then I would have taken responsibility, or would take responsibility for it. I can't remember that.
If we look at page 1, Leslie Sewell emails Martin Edwards and says, just to be clear, these were not undiscovered issues. We brought them to Second Sight's attention for completeness. Also, when Susan and I were crafting the briefing, we were careful in our own wording, as these were associated with potential losses to sub-postmasters in their trading statements. Leslie Sewell certainly seems to be suggesting that you were crafting the briefing and being careful about your choice of language. Do you agree with that or not?
I do agree with that, yes.
Do you think Leslie Sewell was mistaken about that?
No, I think she was right. My recollection must be mistaken.
And it says, we need to be careful in our comms not to indicate that we do not have anomalies or exceptions, as that is not the case. It's the context which is important, and in this case, the fact that they could and did affect trading statements. So we need to be careful in our comms not to indicate that we do not have anomalies or exceptions. I mean, the wording here that's being used, is there an element of smoke and mirrors about the whole thing now?
It certainly reads in that way, yes.
So that's an appropriate moment to take our second morning break. Could we please return at 12:15?
Yes, certainly, Mr. Blake. Thank you very much.
Thank you very much. Thank you. Can we please look at poll 001900429? A meeting takes place with Second Sight on the 3rd of July, with Second Sight, Paula Venables, yourself and Alwyn Lyons. Do you recall this meeting?
No, but we have the notes here.
This is July the 3rd, so it's a day after Miss Venables' husband's feedback on language to be used, and it is also the day of those emails that we saw in relation to trying to think about an injunction in relation to Second Sight's report. It reads as follows. At the beginning of the meeting, James reported that you had told him last week that you had nailed something and that your interim report would show real concerns in the whole process. He thought there was a risk that people who had been prosecuted and were still being prosecuted based on the system, process and software which was not operating correctly, leading to miscarriages of justice. He said he wanted to work with us and that the report could be a triumph for the Post Office. And the body of the meeting need to be very clear about the definition of horizon, and that's something I was mentioning before, that it seems as though there is an increasing focus now on separating out Horizon as a computer system and Horizon as a system that involves the processes of support and training, etc. We accepted that Second Sight were also looking at the wider system, but that we need to be clear, we cannot misrepresent what Horizon, the computer system, means. Discuss the anomalies which the Post Office had brought to the attention of Second Sight during the review. So do you see there that the word anomalies is already being used just one day in?
Yes, I noticed that.
The 64 and 14 cases, he accepted that these are things found in all computer programs and suggested that we use an example of other systems to make that live. He accepted that the most important thing was how they had been managed. Anomalies will lead sub-postmasters to doubt the system. So we need to be clear that this is normal in a system of this size. James was very concerned about an email which suggested that product and branch accounts could be remotely journaled without the sub-postmaster's knowledge. We'll need to be clear about what is happening here. Am I right in saying, and we'll come to it later, but that concerns the issue of what we know as remote access?
I think that was, yes, I think that was the issue that Mr. Rudkin flagged. I can't remember, but.
There is then a meeting at Bond Dickinson on the 10th of July. Can we please have a look at poll 004-07582? It seems as though you attended with Hugh Flemington a meeting at Bond Dickinson with Simon Richardson. Do you recall that meeting at all?
I had a feeling he'd come to us, but I don't recall the meeting, but yeah, we have the notes.
The location is empty, so it may well have been a meeting
Yeah.
at your offices. If we scroll down, 10th of July 2013, number 3, he says, or somebody, has said, the board want to sack Second Sight, and of course are now not coping well with the fact that they are independent. SC, I think that's yourself, is going to arrange to meet Second Sight, and she asked if she could use our offices next Tuesday. I said I could sort a room for her. Do you recall who said that the board wanted to sack Second Sight? Was that your knowledge?
I can't remember who said it.
But do you recall that that was the position of the board at that time?
I think they were. What was the date of this? The 10th of July.
Yes.
I can't recall that they actually said that, but it was my understanding that they were very unhappy with the tenor of the report.
And was that the whole board or particular individuals within the board?
I don't know. I suspect I only got a blended view.
Paragraph 4. She thought it would also be essential to have a session looking at the strategic options and perhaps involving a QC, but she did not want to go back to the one they had used before. She had found him patronising and irritating. Was that Mr. Morgan?
Possibly.
So it looks as though you're considering a legal route.
So my recollection in relation to this note is that, and it's something I've alluded to before, the position we'd reached with Second Sight, they'd got so far down the track with quite a number of the cases, and I was trying to find a way through that they would be able to complete their review more quickly or more efficiently. But I was also starting to take the view that it might not be the right thing to do to leave that process as it was. And I talked to Ian and Ron about it, at Second Sight rather, about it as to how we would manage this going forward.
It continues, paragraph 6, the real worry around the Fujitsu expert who appeared to have known of some of the problems but not referred to them in his report or statement, even though they could be dismissed. There are non-disclosure issues here. They're looking at replacing that expert with somebody else. Was that a concern of yours?
To replace the expert or to...
No, that there had been a Fujitsu expert who had known about some of the problems referred to in the report. I think that's a reference to Mr. Jenkins.
Yes, and also the work that Cartwright King were doing in terms of the disclosure. So I think by that stage, we'd started to do the SIFT review of the, or they had started to do, should I say, the SIFT review of the file, and I was concerned that we made quick progress with that, so that that information could be passed out to the defence solicitors or counsel, and also to the sub-postmaster where appropriate. So I think that's what I'm referring to there.
But that real worry, it seems, about the reliability of Mr. Jenkins's evidence, which was in court proceedings, was that something that, I mean, we have here, you attended with Hugh Flemington. Did you pass that up the chain?
The real worry?
A, the worry, and B, the fact that a Fujitsu expert knew about problems and hadn't necessarily provided a full and accurate picture in evidence.
Yes, I did.
Who did you tell about that?
I think I flagged it to Paula and also to the board.
And we're here on the 10th of July. Was it before the 10th of July meeting, or was it after?
I think, I really can't remember the timescale. There was so much going on at the time.
But the summer of 2013?
Oh, yes, I mean, in July.
It then says there was generally an overall defensive air, and the board are also feeling bruised. There are tensions between people, and that includes Alice Perkins, the chair, Paula Vennells, CEO, and yourself. Can you assist us with what these tensions were at that time?
I felt that I was trying to ensure that the Second Sight review was independent, and by that I meant that they had been given the appropriate level of support and information to enable them to deliver the report, but I had not, and I can't remember whether it was expressed to me at this stage or not, but I felt that I was being accused of not managing the process properly, of not controlling the process enough. But my view was that this is an independent report, and therefore it has to be Second Sight report. It's not our report at the Post Office.
I said that the minister had dealt with the questions extremely well and looked in control of the brief. Evidently, she had the Post Office in to tear them off a strip for not putting someone up earlier in the day for interviews on radio and TV. Was there also tension, as you understood it, with the minister? That's
as I understood it, yes.
Can we please look at poll 00027548?
Mr. Blake, before you ask questions about that, can I just clear my mind? That paragraph 6 that you referred Ms. Crichton to, in terms of the dates, had the Simon Clark written advice been delivered to Post Office by the time of this meeting, or did that come a few days later?
The Simon Clark advice relating to Gareth Jenkins was the 15th of July. This meeting is the 3rd of July.
Exactly so. So that
Oh, sorry. This meeting is the 10th of July. Sorry. So
Yeah.
this predates the formal advice from Simon Clark.
it predates the formal advice, but clearly, Ms. Crichton, what Mr. Clark was going to put in writing must, in some shape or form, have reached you and others in the post office.
Yes, so my memory, and I think it's either in my statements or in some of the documentation, is that they came down to London, I think, on the 3rd of July. I can't remember actually. So I think they came down to London and we had a meeting and I asked them to put their advice in writing, but I also asked them to start the review SIF disclosure. I think that's the timeline.
Right, I understand. Thank you.
And was Paula Venables aware before the formal advice had been received or after, or are you not able to assist?
I can't recollect, but I would have thought it was likely that it would be before the formal advice was received. But I can't recollect exactly. And I think it was complicated by the fact that she was going off on holiday. And again, I can't remember those exact dates.
We've seen from the correspondence and the meetings that took place around this time real concerns at the board level. And also there's reference in that note that I just took you to about tensions between yourself and the chair and the CEO. Were you at this stage coming under pressure in relation to the Second Sight's report and the discoveries that they had included in that report?
So my recollection is that not necessarily pressure, I did feel there was a view, and I can't ascribe that view particularly to anybody, that I hadn't managed the process well. And my view was that it was an independent process and had to be allowed to be independent in those terms.
Did you in any way feel that you had to adjust the way that you carried out your work in order to satisfy the CEO or chair?
I don't think I did. I think I remained of the view that this was to be an independent report. And what I did do is talk to Ian, and we had a Second Sight, and we had a conversation around their report being evidence-driven. And I think that took place probably around the 1st of July. And then I remember that Second Sight issued another version, I think, which was the version I think that was then published.
And in respect of that version, were you concerned by it? Were you happy that it had revealed certain things about Horizon?
I remember being content that it was an evidence-driven report from the issues they had discovered as part of their investigation. I remember being concerned about the length of time it was taking to come to those conclusions. And as I say, that was partly due to the Post Office delay in getting them information. Those are the things, that's my recollection at the time.
Can we please look at poll 000275548, please? We're just going to look at some of the actions that you carried out in July of 2013. This is a document, I think this is the report for the board of July 2013. It has your name at the bottom, 11th of July. And we see there an update on the status of various Horizon claims. And it says that on the 8th of July 2013, Second Sight provided an interim report. This is the subject of a standalone report, and we're going to have a look at that report. Second Sight's initial findings conclude that there were no systematic problems. There are 2 specific bugs which give rise to errors in a number of branch accounts. Second Sight also highlighted shortcomings in the Post Office's internal training and support to sub-postmasters in relation to the Horizon system. So you there refer to, I think you used the words that perhaps used in the second site report of 2 specific bugs. Can we please look at poll 0014547? And this relates to the board paper that is said in this table to be subject to a standalone paper. And we're going to look at the drafting process of that paper. We have here the 12th of July, an email from yourself to Alwyn Lyons, and you had been sent an earlier version of the board paper. And you say, hi, you must have read my mind. Whilst I was out walking the dog, I suddenly thought that it wasn't a good idea to mention bugs, so have changed that, and also found another couple of typos. The recommendation is much better. Thanks. So, I mean, your evidence before our break was that you couldn't remember changing word bugs to other words, but it seems very clear that that was at the forefront of your mind on the 12th of July 2013.
That's certainly what this email says, yes.
We can see the earlier draft of the document that you've been commenting on, and that can be found at poll 0014541. This is an earlier draft of the board paper, and if we look at the background section, it says, as the board are aware, Second Sight have now published their interim report, and this board paper considers the options/proposes a course of conduct for Post Office. Following publication and the MPs meeting, a statement was made in the House of Commons. Various MPs have raised issues. The main concerns seem to focus on the fact that people have gone to prison, and then it says the fact that there have been some bugs in the Horizon system, albeit that Second Sight have found no systemic problems. We look at the later version that's produced, and that can be found at poll 001454428. We see the updated version. If we scroll down, we see it's now been changed to the fact that there have been some defects in the Horizon system. So the word bugs there has now been changed to defects.
Correct.
Do you recall making that change?
I think I must have done. So I don't recall, but I'm the author of the paper, so I must have done.
What would the reaction of the board have been if it had remained in its original version and said bugs in the Horizon system?
I don't know.
Were there topics or words that you thought weren't a good idea to mention to the board or to use before the board?
No, I don't think so.
Was there a culture of some sort about not speaking openly about bugs?
Not that I recollect particularly.
You ultimately produced this paper for the board. I want to take you to an earlier draft. Can we please look at poll 0019160? So the email that I took you to before about walking the dog and suddenly thinking that it wasn't a good idea to mention bugs, that was the 12th of July.
Right.
We have here a draft being sent to you by Hugh Flemington the 10th of July. And I'd like to look at that draft, please. It's poll 0019161. He says, this is where I got to. And this is a much earlier draft. can we please look at page 5 of this? And scroll down to options on claims. Thank you. Is it possible to bring onto screen another version that we just looked at? It's poll 00145428, please. And it's page 3 of that other document. If we could have those two side by side, please. Thank you. Page 3 of the left-hand side. And if we could scroll down, please, on the left-hand side to... that's fine, actually. If we could scroll up slightly, sorry, where you were before. Thank you. So let's look at these next steps. Originally, they were called options on claims and referred to 2 options. You had, on the right-hand side, in the original or earlier version, a reactive approach. We wait for any criminal case to be overturned and for claims for compensation to be made. We then decide whether to settle or fight these on probably a case-by-case basis. Or you have a proactive approach where, following the publicity in the wake of Second Sight's interim report, Post Office could proactively invite sub-postmasters and former sub-postmasters to contact us and raise issues. There is a material and significant risk in the proactive approach, not least because it will lead sub-postmasters to expect compensation. And whilst we may have to pay compensation if we're found to be in the wrong, and it seems as though wording that might be a suggestion to insert some sort of wording, these claims could be considerable, e.g. Excluding the criminal cases, loss of business, home, marriage breakdown, ill health. And then there's a positive recommendation to the board in this original draft. The recommendation is to adopt a reactive approach and assess individual claims on their merits as and when they arise, where it is considered that there is little chance of success for the defendant, that Post Office should defend the claim. This could give rise to the accusation that Post Office is being bullying and unsympathetic. There is clearly a balance which is required with regards to legal costs and paying compensation to defendants, and a policy will need to be developed. The final version is on the left-hand side, and that says as follows. It gives 2 next steps. A proactive approach. There are a number of areas where the Post Office wishes to take a proactive approach, for instance, looking at processes for managing our relationship with our sub-postmasters. And then it says further details will be shared at the meeting. Or a reactive approach. In respect to the criminal cases, the Post Office should wait for those to be overturned via the Court of Appeal and for claims for compensation to be made. We then decide whether to settle or fight these on a case-by-case basis. So it certainly seems that by the 12th of July, in the final paper to the board, the proposal was that in criminal cases, you don't take a proactive approach and assist sub-postmasters, but you wait for them to come to you. Is that correct?
I think by the 12th of July, the Cartwright-King sift had already started. I'd need to go back and check the dates, but I'm pretty sure, because they came, again, I'd have to check the dates, but I think they came to see me on the 3rd of July, and I asked them to sort of start the sift at that point. So basically they came with a proposal as to what needed to be done in respect of the disclosure required by the Second Sight report and the Helen Rose report, and I asked them to start that process straight away, and then that process then involved the disclosure of those reports to the either sub-postmasters or to the solicitors acting for them.
What you're not doing is the right-hand side proactive approach, which is to invite sub-postmasters and former sub-postmasters to contact you.
I think sorry for interrupting. So what I'd proposed to do, as far as I recollect, was to discuss those in more detail at the board meeting. but because I didn't get invited into the board meeting, I didn't get the opportunity to expand on those suggestions in the board meeting.
Where it says further details will be shared at the meeting, is this another example of not wanting to commit too much to writing, or is it something else?
I wanted to flag that there were options that I thought the board should consider, and to be able to make that as a verbal statement rather than have it in writing, from my memory.
Were the board told about the risks that have been identified in that earlier draft?
I don't know. I wasn't at the board meeting, so I don't know what was shared in that respect.
We'll get to the reasons for that, but it had been your intention to attend the board meeting, had it?
Yes, it had.
Yes. It certainly reads on the right-hand side as though it was anticipated that many people would have successful and wide claims against the Post Office.
I think that was certainly my view at the time, but that wasn't necessarily based on data. That was based on what I knew we needed then to go ahead and disclose.
Although you didn't attend the board meeting, was that something, those risks that are identified on the right-hand side, were they things that you shared with the executive team? My recollection is I shared them with the CEO. Around the 12th of July or at some other point?
It would have been around that point. It might have been a bit later than that, but because we'd started working through the Cartwright-King SIFT and looking at the numbers of the disclosures required to be made.
The reactive approach that's discussed there and recommended in respect of criminal cases, the net effect of that was likely to be to delay compensation, wasn't it? Waiting for people to come to you rather than inviting people.
So because of the disclosure process that was ongoing, I just thought it was important. This is my recollection. I thought it was very important to start that disclosure process. And as we see through the other documents, we then asked for that disclosure process to be validated. And further advice came from Mr. Altman. And frankly, I think that after Post Office had got through that stage, then there should have been a step back to say, and what next? So that might have been my advice on the 12th of July, and I suspect it was advice from Cartwright-King, although I don't have that information.
Would you accept that looking back, that was an opportunity missed in which the Post Office could have taken a proactive approach to approach sub-postmasters?
I think in hindsight, yes, it was. And I think in hindsight, that was part of what I was trying to do with the mediation scheme.
Can we please stick with the left-hand side one so the one on the right-hand side can be removed? And this is the final version. Can we scroll over the page, please? There are details here of the criminal cases review. It says the Post Office have been advised by our external criminal lawyers to undertake a review of all cases going back to the time of the migration from Old Horizon to Horizon Online. So this is the SIFT review that you were just talking about.
That's correct, yes.
It says it's important to note that we believe precise records from Royal Mail are not available, that we will have undertaken circa 55 prosecutions a year for the past 10 years. Our external lawyers have advised us that they believe there'll be around 5% where they need to disclose the additional evidence, and then it will be up to the defence lawyers to consider the evidence and apply to the Court of Appeal. Each individual has to seek leave to appeal to the Court of Appeal if they want to seek to overturn a conviction. The Court of Appeal will look at each case on its merits and will consider what evidence a person was convicted on. For example, there may be horizon evidence, but also other paper trail evidence, or even admission of guilt. It is by no means certain that each appeal will be successful. And then it says, we may also face civil suits for wrongful conviction. The consequences of this are malicious falsehood, defamation, wrongful termination, harassment. If we abandon prosecutions, may also face claims for example, malicious prosecution. Quite severe consequences potentially facing the board at this stage.
Yes, I agree.
Now, I want you to look at that 1.1 where it says our external lawyers have advised us that they believe there will be around 5% where they need to disclose the additional evidence, and then it will be up to the defence lawyers to consider the evidence and apply to the Court of Appeal. On a previous draft that I've taken you to, it says, in fact, very different wording. It says that 5 to 10% of cases may be overturned. Could we please go back, or if it's possible to have side by side, poll 00191 and the second page of that, please. Thank you. So this is the earlier version that I took you to before the Hugh Flemington draft a couple of days earlier. If we scroll down on the left-hand side to 3.4.2, in that earlier draft it says it's important to note that we believe precise records from Royal Mail are not available, that we will have undertaken circa 55 prosecutions a year. Our external lawyers have advised us that they believe there will be around 5 to 10% of these which may be successfully overturned and the convictions quashed. Now, you were the author of the final version and submitted that to the board. Are you able to assist us with how it came about that 5 to 10% which may be successfully overturned became 5% where they need to disclose the additional evidence?
I can't remember exactly, but do we have a date for the first draft? Because
we do.
I was getting...
The first draft is well, it was sent to you by Hugh Flemington on the 10th of July 2013.
And this would have been done for the board a couple of days later, maybe 2 or 3 days later?
The final date on the right-hand side is the 12th.
So I think what I was doing was, when I was in contact with the criminal law firm who were doing the review, and I can't remember exactly, but it may be that they gave me that revised information in the meantime. But I cannot remember. But that
it's a very significant difference, isn't it?
Yes,
5
it is.
to 10% gets changed to 5%.
Yeah.
And successfully overturned gets changed to they'll need further steps before they can they might successfully overturn.
Yes, it is.
Did you make that change yourself?
I think I must have done, yes.
And who were the external lawyers that you spoke to in relation to that?
That would be Cartwright King, I think.
Do you think in some way it was intentionally watered down?
No, I don't think so. I think I was just stating the facts, I suppose.
But they're quite different facts, aren't they?
Well, the 5% is clearly very different. But I think also I had a better understanding of what the process would have to be. When I can't remember exactly. I'm only speculating now.
Were you concerned that the board would react quite badly to being told that 5 to 10% may be successfully overturned?
I don't think so, because it was a fact. It was, and I would have been guided by Cartwright King, who were undertaking the review.
Do you remember who in particular you spoke to at Cartwright King?
No, I can't remember.
Who was it likely to have been?
Maybe Martin Smith. There was somebody I was in correspondence with, which is in the documents where I'm going backwards and forwards about how many have you done, how many think, when will you get it done, how's it going on.
Thank you. That can come down, please. Can we please look at the board minutes of the ultimate board meeting on the 16th of July 2013? That's poll 000-21516. We can see there Alice Perkins, some non-executive directors, including Susanna Story, who I think was from UKGI or SHEX at that time, Paula Venables, Chris Day. You're not in attendance. Why weren't you in attendance at that board meeting?
Because I was waiting outside to be called in.
And who had asked you to stay outside?
So the process for the board meeting was that you waited outside the room at around the time of your slot, and then the company secretary would come and get you when the board had reached the point that you should appear on the agenda.
And did the company secretary come and get you to present on the very paper that we've just been looking at?
No, she didn't.
And do you know why she didn't?
I'm trying to remember what she said to me at the time. I think she said that they had completed the discussion and that one wasn't required.
Can we turn to page 6 of these minutes, please? Horizon update. So this is presenting the paper that you had produced. The CEO explained that although the second site report had been challenging, it had highlighted some positive things as well as improvement opportunities. Just pausing there, would it have been normal for the CEO to have presented something like this?
In general, what would happen if you had a specialist topic at the board, you would go and present that paper? So I mean, she might give a short summary at the beginning, but in general, if it was your paper, you should go and present it.
The business had been praised in Parliament for setting up the independent review. The proportionality of the tiny number of cases had been emphasised, and no systemic issues had been found with the Horizon computer system. However, there were cultural issues which had to be addressed to improve the support we gave to sub-postmasters. The CEO stressed that this was now a catalyst to make changes in the business. It says the board were concerned that the review opened the business up to claims of wrongful prosecution. The board asked if Susan Crichton, as general counsel, was in any way implicated in the prosecutions. Were you aware that there was going to be board discussion about you in particular?
No.
And what is your understanding of this paragraph?
Just reading it again. So my understanding is that the board were asking the CEO whether I was implicated in the prosecutions, and in other words, bringing the prosecutions against the sub-postmasters.
C, the board expressed strong views that the business had not managed the second site review well and stressed the need for better management and cost control going forward. Now, where it refers to the business, what do you think they had in mind?
Well, I think it was me, but I don't know what was said in the meeting.
The board accepted that this was an independent review and therefore things could happen that were beyond the control of the business. However, the things that could be managed by the business needed to be well managed with strong leadership, and the board asked the CEO if she had considered changing the person leading for the business. Considered changing the person leading for the business. Who was that person?
That was me.
The CEO had considered this and recognised that the business did not have good governance in place around second site, but that the independence of the review and the input from MPs and Justice for Sub-Postmasters Alliance had made this complicated. The business did not have good governance in place around second site. What did you understand, or do you understand by that to be a reference to?
So now I understand that to be that I did not control the second site delivery of the report, is what I understand that. I think that's what I understand that to mean.
And we see at the end there, the chairman asked for a review, a post-mortem, to report to the ARC, is that Audit and Risk Committee?
That's correct.
Yes. Explaining how we awarded and managed the contract. This should be put in hand swiftly. One final document before we break for lunch, can we please look at poll 000999210? This is the board agenda, so this is the original agenda. If we scroll down, 11:40 Horizon update, it looks as though it was going to be you and Mark Davies who were going to speak to that issue. Is that the correct interpretation of this agenda?
It is, yes.
Can we please turn to page 105? We see this is the document that we looked at earlier. So this is a document that you produced, your significant litigation risks table. If we scroll down, please, to page 106 and 107. 106. Over the page, please. We have a list there of principal criminal cases brought by Post Office Ltd. Did you prepare this table?
I think it was prepared by either Janat. I think it was prepared by Mr. Singh.
Okay, but it has your name at the bottom. You took overall responsibility for
Yes, it
this
reported
paper.
to me, yeah.
And we see there reference to 2 assistant sub-postmasters accused of covering shortages by delaying the processing of business deposits to Santander. The case concerned 40 deposit slips being suppressed. I think that is a case that we've looked at. Both defendants pleaded guilty. They were sentenced to 5 months and 6 months. Sub-postmaster accused of theft of plenty of entries, sub-postmasters being accused of theft, and various figures, references to defendants pleading guilty, Crown Court trial fixed. The case has been committed to the Crown Court. The defendant pleaded guilty and was sentenced to 9 months imprisonment, suspended for 18 months. Sub-postmaster accused of 2 offences of theft and 2 offences of false accounting. That case had been committed to the Crown Court. Sub-postmaster accused of fraud. Defendant pleaded guilty and was sentenced to 16 months imprisonment. So the same board, if we scroll down, being made aware at the same time as issues concerning the second site report of sub-postmasters continuing to be prosecuted and continuing, there's a hearing date to be set there. We see Paul has recovered, so still recovering money. Further inquiry undertaken by the investigation team. So the investigations team was still investigating, the lawyers were still prosecuting, and all these matters being brought to the board's attention on the same day as the report regarding the second site report.
That's correct. It was in the same board pack.
Yes. And we also have the board paper that you produced that we looked at. I don't need to take you to it, but albeit it doesn't now say 5 to 10% of cases will be successfully overturned, it did at this point say that the second site report will need to be disclosed in 5% of cases. And there's that final page that I took you to, which mentions various civil suits for wrongful convictions, etc. And that paper went to the board on that occasion as well.
That's correct.
Is it surprising that there isn't more discussion at board level of the link between the second site report and all these prosecutions and investigations that were still continuing?
I find it surprising, certainly with hindsight, but even at the time I found it surprising.
Thank you, sir. That might be an appropriate time to break for lunch until 2 o'clock.
Yeah, sorry. There is. Can we go back to the agenda again, please? There's something that's niggling away at me that I want to clear up.
So that is the first page of the previous document.
Yeah.
So it's poll 000999210, page 1. perhaps we could scroll, zoom out a little bit.
Right, thank you. Now, let me see if I'm understanding this, Ms. Crichton. Item 4, Horizon Update. To be delivered by you and or Mr. Davis, I suppose. Do you know whether Mr. Davis delivered a report?
I don't think he did. Can you see from the minutes?
So it may assist if we look at poll 000021516, which are the minutes, Mr. Davis is not listed as being in attendance.
Right. So neither of you were involved in that. Sorry, we've gone to the minutes now. Can we go back to the agenda? What was intended? And then if you go down to item 9, you were to provide either a paper or a report, I'm not quite sure which, in relation to group structure. Yeah?
Yes, that's correct. It's on the agenda. I can't remember whether Interim did that or not.
All right. So then item 11, the significant litigation report which you had taken responsibility for, even if you may not have drafted, for some reason that was being presented by Alwyn Lyons. I know she was company secretary. What was the thinking behind that, so far as you were aware?
So it was a noting paper. So,
right. So there was to be no discussion of it. Is that what that means?
No, it means that it's there to be noted by the board, but if there are any issues in the board that the board wishes to raise on that, they can raise it. And it can either be dealt with via the minutes or an action item. So, for instance, if the board had said, can you give more details about this or that, that would have been in the minutes and would have been a board action item, which would have then come to me to deal with. But so it was absolutely, you could absolutely discuss them, but so things like the company ceilings and the health and safety report and the significant litigation report were, I think, from memory, always items for noting.
Right. The document in which you ultimately said that 5% of there may need to be further disclosure in 5% of past cases. Can you identify for me where that might have come up in terms of the agenda in respect of items 1 to 12, so to speak? Where would that have fitted in?
So that would have been item number 4, the Horizon Update.
Right. So that's where either you or Mr. Davis would have had the opportunity to speak to the report, but it appears that neither of you were asked to do so. Have I got that correct?
That's correct.
Okay, so sorry to go back over that, but I wanted to be clear how these things work.
Absolutely. So can I just ask 2 questions that follow
Yes,
up
of
from
course.
that?
Yeah.
If we go back to the board minutes, poll 000211516, and we look at page 8 of that. We see at the bottom there group structure, and that was one of the items that you, it seems, were due to address. And there isn't reference to you there. It has an action point for the CFO, and if we scroll down the page, action CFO, action company secretary. Are we right in understanding that despite that matter not being about Horizon, you still hadn't been invited into the room?
I think that's what I remember happening, yes.
Thank you.
So we better make it 2:05 now, Mr. Blake.
I would, yes, let's go for 2:05. It might be that we run into tomorrow morning with Miss Crichton. She is aware of the possibility of that.
Yeah, well, I understand that, you know, it's difficult to be precise about the length of time of questioning, as this inquiry has proved on occasions, and as inconvenient as it may be on occasions for witnesses, I'm afraid these things do happen.
Thank you very much, sir. 2:05. Good afternoon, sir. Can you see and hear me?
Yes, I can, thank you.
Thank you very much. So the first document we're going to look at this afternoon is poll 00118-496, please. This is a note, a file note from Paula Venables, dated the 26th of July 2013, and it relates to a conversation that she had with you on the 24th of July. I'm going to spend a bit of time on this document, and I'll take you through some of the key paragraphs in this file note. She says, purpose, to make clear to Susan that she's accountable for the process going forwards, and that there are 3 areas of concern that I have going away on leave, and also in order to protect the business as much as possible, to reassure her that I believe she can do this, in order to give her the confidence to do so, and to avoid any misunderstanding or possible demotivation in the process. What was your understanding of the purpose of the meeting?
I can't remember. It might have been our first one-to-one after the issue of the report, but I'm not sure.
I mean, we've seen the board minutes and concerns raised at board level. Was this the first opportunity to discuss what happened at the board with Paula Venables?
That would be my recollection, yes.
And what did you understand by protecting the business? Was that something that she brought up with you?
Yes, she did. I think she felt that... I think what I understood her to say was that she felt that the second site report could have been very damaging for the business.
She says, I asked Susan how she felt the meeting with Alistair Marnock, chair of the Audit and Risk Committee, had gone. She thought he had understood and was supportive of the process. I confirmed that was the case, and that he was particularly reassured that we had the legal and independence aspect covered. I also said that I now had 2 or 3 conversations with the chairman, who, although she was still very concerned about the whole issue, was more reassured that we're taking the right approach, which included Susan seeing this through. I suggested that Susan should see Alice. Susan informed me that she had already secured a date next Thursday, the 31st of July. Can you assist us with what the purpose of the meeting with Alistair Marnock was?
So he had been tasked, or he might have volunteered, I don't know, he was the chair of the Audit and Risk Committee, to come and meet with Olwen and I so that we could take him through the process that we were going through, or I could take him through the process we were going through, as I hadn't had an opportunity to do that at the board meeting. Can I just add that I hadn't seen the minutes of the meeting either, so I didn't understand what had been said at the meeting, and I was also keen to understand that in case there were issues rising from that I needed to know about.
So you hadn't been invited into the meeting, and you hadn't seen the minutes of the meeting, and we're now 26th of July. Was that a surprise to you?
Yes.
It says Alice Perkins was very concerned. Were you aware that she was very concerned? And if so, what were you aware of?
I think I knew she was concerned, but I didn't particularly know why, because I felt that I delivered on what she'd asked me to do. At least, we'd got to the interim report stage. So I didn't really understand why, and I did think I had to meet her and talk to her. And I was very concerned that following standing outside the board meeting for an hour, where on earth do you go from here?
The note says, I outlined 3 concerns that I would want Susan to be clear about and have actions in place to deal with. The first is costs. The second is delivery of work in progress. It says, Susan felt Angela and her close Susan felt that via Angela and her close working with Second Sight, we should be able to manage the above 2 points. Her concern centred on the Justice for Sub-Postmasters Alliance and keeping them to any approach agreed. My observation to her was that Alan Bates will be subject to the same pressures as George Thompson. Alan Bates / George Thompson agree a sensible way forward, but when they go back to their members, they're accused of going native and then sent back with different and usually more extreme requests. The only way around this is to stay very close to Alan Bates to be in touch once or twice a week to check he has the support he needs and to listen out for any concerns that may be building. Can you assist us with that paragraph and what was being suggested there?
So I would say that the Post Office developed a very close relationship with George Thompson, who was the Federation of the National Federation of Sub-Postmasters, and she was suggesting that I should develop the same kind of relationship with Alan Bates, which I didn't have any issue with developing that relationship, but I felt it had to have a purpose.
If we scroll down the page, another one of the objectives, it relates to the JFSA, and then it says as follows: Susan was initially frosty in her manner. She's clearly feeling the pressure, which is understandable. I hope that I reassured her, and within a few minutes we were talking normally. She relaxed and we had a useful conversation, as noted above. Is that an accurate description of you on that occasion?
I think I would have been frosty, yes, given the board meeting issue. And I think I was concerned about my position vis-à-vis the board. Probably I would have been talking normally because that would be my normal way I'd behave.
She says, I remain concerned that Susan is not organised or structured, nor is she a leader. These gaps in her capability are risks to the business. They're being dealt with by supporting her with individuals who are organised and structured and by a process to monitor. She remains a good advisor. I will review the longer-term decision in September. Does that accord with your recollection of the discussions with Paula Venables on this occasion?
She didn't mention those things to me.
No. And what is your feeling about what's said there?
I suppose I would disagree with those, and I think my career demonstrates that's not the case.
Were you aware that your future was going to be determined in September or reviewed in September?
Not at that time, although when I reflect on it, it's not entirely unsurprising.
We know that you received the clerk advice relating to Gareth Jenkins on the 17th of July. We're now on the 26th of July. There doesn't seem to be a mention in this email of concerns about historic and even ongoing criminal cases. Why is that?
I think because that was the role that Alistair Marnock was taking. So part of part of our discussions was to go through the review process that Cartwright King and to explain why we were doing it and what we were doing. At least that's what I remember us doing. We spent quite a bit of time on that.
So was it not your responsibility to draw that advice to Paula Venables' attention?
I think I had flagged it to her. I just can't quite remember when.
Would it be around that time?
I would have thought so. I think, yeah. It would have been part of the discussion around the Cartwright King review and why they're doing and what they had to disclose and why they had to disclose it.
Is it surprising, though, that on the 26th of July you had a meeting with the CEO and no concerns are raised in that meeting about the safety of convictions, for example?
I think I had done that with Alistair Marnock, so she would have had that call, and he did a note. I think it is surprising, yes, in retrospect.
So it's surprising, but you thought that it was being taken forward by Alistair Marnock?
Yeah, and if you go back to my recommendation in the board paper, I think that asked for the ARC to review the prosecutions policy. I think it was in one of the drafts anyway, in September, as part of the ARC meeting.
Do you think that that lacked some urgency, given the advice from Simon Clarke?
Probably, yes. But we were then doing the disclosure, and also I had asked that prosecutions be ceased, but I'd asked that they would be reviewed as per the post-separation issues.
But they were continuing?
As far as I was aware, yes.
Can we look at poll 00006590, please? This is a document of the 28th of July 2013, sorry, 26th of July 2013, and it's entitled Update on the Work Programme Arising from the Horizon Report. So that was produced, I think, on the same day as your meeting with Paula Venables. Sorry, the same day as the email note from Paula Venables, 2 days after your meeting. Do you know who drafted this document?
I don't know who drafted it.
We'll see somewhere there's an email chain where it's sent by Paula Venables. Would it surprise you if Paula Venables herself drafted this?
No, it wouldn't surprise me, no.
On page 1, you hadn't been asked to provide or produce a document like this.
I don't think so.
Because we saw in the board minutes that there was a request for an update on the work.
Yes.
But that was, as we've heard, a meeting that you weren't in attendance.
No.
Page 1, further to the board discussion on the 16th of July, this note provides an update on how we're taking forward the programme of work in response to the publication of the Second Sight report. Now, given that you had actually produced the note for the board for the 16th of July, and were due to speak to that, is it surprising, or were you surprised, that an update was being provided by somebody other than you?
I'm surprised, but I can't remember writing this, or it's not the way, it's not my typeface. But yeah. So yes, I don't think I did it, and it is surprising to me, but I can't remember.
If we scroll down the page, point 4, we've been focusing on developing an approach to respond to these expectations, which balances the requirements to be cost-effective, time-efficient, and credible. 2 specific concerns about Second Sight. First, as a 2-man team, they don't have the capacity to deal with all of these cases within an acceptable timescale. And secondly, their approach of seeking to reconcile the conflicting evidence and views of the Post Office and sub-postmasters, which stems from a steer from James Arbuthnot that they needed to keep the JFSA on side, is pushing them into an almost impossible situation, which both extends the time taken to conclude each case and, more worryingly, creates a tendency for them to place greater weight on the sub-postmaster's version of events, irrespective of the evidence we present. Was that a view that you were aware of?
No, I don't think I was. I can't remember being aware of that view. I don't remember that there was the concept that it was irreconcilable. I thought it was a question of them stating their case.
Were you aware of a concern in the business at this time that Second Sight were tending to place greater weight on the sub-postmaster's version of events?
Possibly within the business, but it wasn't a concern that I shared, I don't think.
We propose to address these concerns through 2 specific measures. The first, restricting Second Sight's remit to the specific task of preparing an impartial evidence base. And over the page, changing the way we work with Second Sight by allocating additional senior-level resource with a deep understanding of the network to work closely alongside them in order to answer their queries and help them prepare as accurate an evidence base as quickly and efficiently as possible. If we move on, please, to the 26th of July, can we look at poll 002979994? It's around this time there's an email discussion about the board's own potential liabilities raised at a 23rd of July board meeting. This is an email to yourself from the head of corporate finance, and he provides a suggested response to a question raised at the 23rd of July board meeting. The board requests further clarification on their position as directors. In summary, is it highly unlikely that any individual director would have any personal liability in connection with this review unless they had acted in bad faith or maliciously? In the unlikely event that an action is brought, could only be by Post Office Ltd or in very rare circumstances by the shareholder acting on behalf of the company. There is insurance cover in place to cover directors, etc. Were you aware of a concern at board level about their own personal liability?
think that's been fed back to me as one of the questions raised by the board to be covered off in this paper, which is why I talked to Charles Colquhoun about it or asked him for his view on the policy.
And was your impression of the board or the executive at this time one of concern about their own personal liability?
I think possibly at the board level, because that was what was fed back to me from the board meeting.
Does anything stick out in your memory in that respect?
No, I don't think so.
You then have a meeting with Susan Crichton. Can we please look at poll 00381455, please? Sorry, with Alice Perkins. AP meeting with Susan Crichton, 31st of July at 148 Old Street. Again, this is another note that I think I'm going to have to take you to in quite a lot of detail. She begins the note saying, I opened by saying that I had wanted the meeting because I felt uncomfortable about the fact that Susan Crichton and I had not had a conversation since the Second Sight interim report had been published a few weeks ago. I had not wanted to go on my holiday without talking to her. I first asked about her health, as the last time I had seen her on her own before the June board away day, she had been unwell. Are we to read anything into that? Were you feeling unwell as a result of your work, or was it entirely unconnected?
I think where I come out to it on reflection is it was actually making me quite ill.
It says that you were very cool in your manner at the outset. You had a number of questions which you wanted to ask. You started to write down what she was saying in your notebook, and she remarked that it seemed as though you were turning it into something very formal, which was not what she had in mind. She wanted to talk to you about how you were and how you felt about things. Is that an accurate reflection of what occurred at the beginning of that meeting?
I can't recall that, but it could have been.
It then goes on to say she said she'd been very unhappy about being kept outside the board meeting for an hour and then told her presence was not required. She said she was not prepared to be treated as a scapegoat. Why were you concerned about being treated as a scapegoat?
So I felt at the time as if I had delivered on what she'd requested, albeit by the interim report, that I hadn't been allowed to go and explain to the board my position and kept outside, and I didn't have another channel to talk to the board. And you'll see later that I think I make clear that as a general counsel, you can't operate in a business if you don't have the support of the chair, the board and the CEO.
And how were they going to treat you as a scapegoat?
So my view was that within the board context, I suspected, because I didn't know, that the chair had not been clear, and it was her instructions that we instituted the Second Sight review on the basis that we did, as in an independent review. And if it was an independent review, then that's what it had to be, an independent review.
It says, I said that I hoped she knew me and the board well enough to know that we were not interested in finding scapegoats. That was not my approach, and no one had in mind to make her into one. I apologised for the fact that she must have felt uncomfortable outside of the boardroom, and explained that after Paula Venables had, at my request, introduced the agenda item on Second Sight privately, the discussion had developed quickly, and it had not been appropriate at any point to bring her in. So the suggestion seems to be that she had requested the CEO to introduce the item, and that there hadn't been, it went quickly, and it hadn't been appropriate to bring you in. What was your reaction to being told that?
I said that I thought that was not appropriate. I said that it was a significant piece of, should be a significant, I think what I said, something along the lines of, it was a significant issue for the board and there should have been a full discussion, and I should have been there to explain my views on the issues in front of the board.
The agenda had been really packed, partly because we had to add this piece of business, and I had decided that once the board's private discussion was over, there was no time to pursue the conversation further with yourself. Did you believe that?
Well, it's what she said at the time. But no, I didn't necessarily believe it because I knew it was on the agenda.
And we also saw that you had been due to talk about another item on the agenda.
Later in the, yes, on the corporate restructure.
And to your recollection, am I right in saying you don't believe that you at any point entered the room?
No. It would have been very difficult for me to go in and talk about the corporate restructure after not coming in to talk about the second site report.
I had realised that that would be difficult for her. She said that she needed to know that she had the full confidence of the board. No one had told her what had been said at the board, though she understood that there had been some difficult questions, especially from VH. Is that Virginia Holmes?
Yes.
And she was a non-executive director.
Yes.
Why do you think there were some difficult questions from Virginia Holmes?
I think Alman probably told me that. But didn't
So-
really give me any detail.
So you did have a line into the board from Alwyn Lyons in terms
Yes.
of feeding back what had happened.
Well, only at a very high level.
And what had Alwyn said about Virginia Holmes?
I can't remember now, I'm sorry.
Did you get on with Miss Holmes?
It was a professional relationship.
Do you have any concerns about her?
No, I didn't really know her that well. She hadn't been on the board for that long, I don't think.
It says that your reputation was at stake. Were you concerned about your reputation?
I felt that it was important as an in-house lawyer that you were able to behave in a way that had integrity, and having been tasked with delivering an independent report, then that's what you should do.
It says, I said that the second site interim report and the timing of its publication had been potentially very serious indeed for the Post Office in terms of our national reputation and the effect it could have on our funding negotiations with government. In the event, it had not come out so badly, partly because of the way the Minister had handled her statement in the House of Commons, but it had been very worrying at the time. Can you assist us with that paragraph, please?
So I think as part of the James Arbuthnot discussion, he'd asked Joe Swinton, I think, who was the Minister at the time, to go before the House of Commons, and he'd asked a parliamentary question that she had to answer, from memory.
Yes. And in terms of funding negotiations with the government, what were the concerns there?
I can't remember where we were in the funding cycle, but Post Office relied for funding on the government. And it may be, I'm not completely clear on this, that we had a 1 year, we had maybe had a 1 or 2 year funding agreement as part of the separation from Royal Mail Group, but I really can't remember. It would seem strange that we'd become independent with only a 2 year funding arrangement, but I can't remember, I'm afraid.
It then says the board had been unsighted on the issue. They had naturally been alarmed when they had found out what had happened, and the fact that the board paper had been so bland had not helped to build their confidence in the handling of the affair. There had been the possibility of a discussion on a board call the previous week, but because we had needed to discuss issues in relation to the strategy and funding negotiations with the government, which required board decisions, these had to come first, and we had run out of time for the second site issue before people had to leave the call. In the course of what followed, the following points were made. You said that you now thought it had been right to have the inquiry, as it revealed the imbalance of power between the Post Office and sub-postmasters, which needs addressing. This was a huge and complex issue for the business. Can you assist us with the words there and what it was that you said?
I think as part of the work that Second Sight did, it really brought it home to me, and I'd already had a discussion with the team as part of our review of the Post Office contract some time previous to this, that we needed to look at the contract to redress the balance. I likened it, because of my background, to a consumer contract with a large corporate, and that was borne out by certainly the feedback I'd got from Second Sight. But this was a fundamental issue for the business that they needed to address.
And the note continues, I commented that I thought that although the outcome had in some ways been good for the Post Office, the way the process had been handled had been deeply flawed. I had backed your judgment on the appointment of Second Sight because we did not want to appoint one of the big four. You seemed very confident in them, and given your strongly stated opinion to having an inquiry in the first place, she had wanted to feel some ownership, wanted you to feel some ownership of the process once we had decided to go down that route. We had lost control of the process. I had lost confidence with Simon Baker early on, but had been told repeatedly that he was good and capable of handling the role. I said that we should never have got into a position where we did not see the draft Second Sight report until days before its publication. So pausing there, it very much seems as though you're being blamed in that paragraph.
It feels like it, yes. And I think with regard to Second Sight, I hope I've made it clear that although I knew Ron Warmington, we were not friends, and I very deliberately, I think, stepped out of the selection process and allowed them to talk to Alice Perkins and Paula Reynolds themselves, because it was key to me that both parties accepted what they were getting into at that point, as in a proper independent investigation.
Was it your strongly stated opinion that there should be an inquiry in the first place?
Yes, it was.
And were you a sole voice in that?
It felt a bit like it at times, yes.
It continues, I understood that Second Sight's investigation had to be independent, but in the civil service, there would have been someone marking it who was close to all the key people, Second Sight, James Arbuthnot, Justice for Sub-Postmasters Alliance, and knew what was going on between them. By the time I'd find out how Second Sight had, in effect, changed the terms of reference to which they were working, it was too late to retrieve the situation. The organisation and people in it should have had proper time to consider Second Sight's findings and respond to them. It says that you questioned her understanding of the end game and said that Post Office had seen the report days earlier. You had been contacted by the CEO whilst you were unwell about this and had come back early from your holiday to handle it, which had not been ideal. Can you assist us with the reference to the civil service? There would have been someone marking it who was close to all the key people.
I mean, I don't remember this part of the conversation specifically, but I assumed what she was talking about was that in the civil service, of which I had no experience, there would have been a level of control over the report that I hadn't exercised.
Is it a suggestion that although it would have been an independent report, there would have been some influence by those who are being investigated?
Yes, I think that's probably right. That's what I understand this sentence or these paragraphs to say.
Is that how you understood the conversation at the time?
I think so, yes. I think it was.
It says that you said that as a lawyer, it's inappropriate for you to influence the key stakeholders. You would have been criticised had you become close to them. And Ms. Perkins commented that if you had felt unable to play that role, you should have flagged it up and someone else could have been brought in to perform it. Privately, I'm astonished at this view, which I simply do not recognise from my experience elsewhere. Did you and do you consider that it would be inappropriate to influence the key stakeholders?
I think the role I was trying to play for Post Office was to be an independent intermediary so that Second Sight got the information in the form that they wanted it. I wasn't always successful, and certainly timing-wise, things took too long to do. But that's what I believe my role was in this context.
And analysing that paragraph, what do you recall of the conversation with Ms. Perkins?
It was very frosty. suppose I'd characterise it as being a very difficult conversation.
It says that you said that you were in a difficult position now. You needed the board's full confidence because so many aspects of what you were being asked to do were beyond your control. She said that she realised she couldn't control everything, but this was not like an unexpected meter exploding out of nowhere. Do you know what that
I
meant?
think it might be mortar.
Mortar. We needed to identify the worst things which could happen, face them and work out how we would mitigate them. We needed to stay close to the key players and ensure that they were building their trust and we knew what was going on between them. That would take time, but I did not accept the degree to which you had claimed that they were beyond your control. They needed managing. I asked about Second Sight's role going forward and said I thought it was critical that we capped off their involvement at the 47 cases already in the frame. We could not allow them to become involved in any additional cases as we would find it much harder to bring their involvement to an end. You said that would be very difficult as James Arbuthnot and Justice for Sub-Postmasters Alliance rated them. She pointed out that the Post Office did not. It was up to us to propose very quickly alternative arrangements going forward, which would command the respect of James Arbuthnot and the Justice for Sub-Postmasters Alliance. We then talked about cost and the need to appoint any independent figures carefully and rigorously. If we go over the page, please. I think there's a paragraph there where I think you were critical of Simon Baker, that he hadn't been of the right calibre.
I thought Simon Baker did a really good job as a project manager. In retrospect, I don't think I would have said that. I think he was, relatively senior in Leslie Sewell's world, and he could sort of make up for my lack of technical expertise and knowing what to ask for and getting stuff done. And I think that Second Sight appreciated that and thought he'd done a pretty good job.
The problem was that there were too many well-paid people in the business not performing as they should be. I said I had thought this issue was being tackled through more vigorous performance management, to which her reply was that she was referring to people below the senior leadership team. Can you assist us with who you were referring to, if that is an accurate description of what you were saying?
I don't think it was an accurate description. No, I don't think I would have said that. And I certainly can't specifically remember saying it.
It says, by the end of the conversation, your tone was less formal and cool, but her confidence in your judgment on key issues, and in particular your fatalism or reluctance to see the importance of managing events and people rather than standing back and letting them happen, were very troubling, though I did not say this in terms. I deliberately did not say anything about the board's or my confidence in her, and after the beginning of the conversation, she did not raise the point again. I did not explicitly raise the issue of the way Second Sight's costs have been allowed to spiral out of control, because I did not want the conversation to become the post-mortem, and there were already enough issues on the table between us. P.S. At one point, you referred to a recent conversation with the biz team, at which one of them had commented that they had always felt uncomfortable about the Horizon cases. When you had asked why they hadn't pursued that, the person had said it was because the Post Office had always been so forceful in its defence of the issue and its handling. Are you able to assist us with that conversation with the biz team?
I'm really sorry, I can't remember it. I worked closely with the biz team throughout the state aid and the separation. I didn't have much conduct after that, so whether it was during that period, I don't know. And I can't remember who it was who said that to me.
Who were the biz team?
So on the state aid, it was Will Gibson, and there was somebody else who helped him. So they would have been my main points of contact. I'm afraid I can't remember his colleague's name.
I'm just going to take you back to your witness statement on the topic of this entire meeting and the meeting I've just shown you before with Paula Venables. Could we look at WITN 00220100? It's page 86. Thank you. Page 86. There are some parts in your witness statement where you've addressed comments that have been made by Paula Venables. If we scroll down, you say at paragraph 239, as to Ms. Venables' comments in her emails to Ms. Perkins on the 26th of July 2013, I was not at the time aware of Ms. Venables' criticism of me. The next paragraph, as to whether I consider these criticisms to be fair, they were never communicated to me, and I do not consider them to be fair. I have held a number of senior roles during my career, and these are not criticisms I have ever faced. If we scroll down to 246 and 247, sorry, I scroll up slightly. Thank you very much. Regarding whether I was aware at the time of Ms. Venables and Ms. Perkins' criticisms, I was not aware of them. In respect of whether I considered these criticisms to be fair, I refer to my explanation above. I was not aware of these criticisms at the time. They were not criticisms I had faced from colleagues before or since. We've just seen two file notes, one from Paula Venables, one from Alice Perkins, detailing meetings you had with them, at which they seem to have been quite blunt about certain criticisms of the way that you approached things. Do you think, looking back at your witness statement here, that's accurate?
So obviously I hadn't seen those notes before I wrote this, and I suppose because they were talking about my lack of ability in organisation and as a leader, I wouldn't say that those two notes really addressed that. I would say that they, well, maybe organisation, I don't know, but that's not how I would necessarily characterise those notes. Now that as I said, I didn't see them when I'd written the witness statement.
What your statement doesn't seem to do, though, is to give any idea of the strength of feeling that appears to have been present in the summer of 2013 between you and the senior leadership of the Post Office.
So I think in relation to the chair, I make some reference to the relationship there and said it was cool, or I can't remember exactly, when I had a meeting with her and it was frosty, because I didn't necessarily remember all the detail of that. I certainly remembered that I put to her the point about independence.
But the relationship was pretty bad by that stage, it seems.
I think that's probably a fair summation of it, yes. But again, I had frankly not forgotten it, but probably moved on from it.
Can we please look at poll 001161114? This is the same day as that meeting. It's an email from Alice Perkins to a number of different recipients. She's thanking Alwyn Lyons for the note. If we scroll down to page 2, we can see Alwyn Lyons has sent an email saying, "Dear all," it's the bottom email there, "please find attached a detailed note from Paula providing an update on our programme of work in response to the Horizon investigation." And you recall I referred to that note and we weren't sure who had drafted it.
Is that the note that was...
I believe that is.
Right.
Would that surprise you?
No, it wouldn't. I was just,
But if we scroll up, please. Page 1, Ms. Perkins is referring to the way forward, board note on Horizon. She says, first, while it's clear that we're committed to using Second Sight for the 47 cases which are already in the frame for this review, it's extremely important that we cap their involvement at that. So that's something that was communicated to you on the same day. Second, we need to cap Second Sight's costs. And then further down it says, finally, I've asked Susan to keep the board fully informed of future developments and to alert me to anything which she's unable to resolve, which could get in the way of getting the job done in the way it needs to be done. She will be seeking conversations about all this with all the non-executive directors on an individual basis and will be in touch with you to arrange these. Why were you speaking or needing to speak to the non-executive directors at this stage?
I presume she said that on the basis that I'd asked her if I had the confidence of the board. And so it was sort of, well, talk to them and find out. Was the sort of impression I got.
Did you talk to them and find out?
From memory, I'd certainly spoken to Alistair Marnock. I can't remember about the others.
And what impression did they give you about your future in the company?
I just can't remember. I think I was sort of on the way to making my own decision, to be frank.
Can we please look at poll 001457993? We're now on the 1st of August, so the next day. If we could start on the second page, please. There's an email from yourself to Paula Venables. And if we scroll down, that's the email. You're providing some updates on the Horizon project. If we scroll down to Second Sight, you seem there to be putting into practice what Alice Perkins had asked regarding the 43, minimising Second Sight's involvement, limiting costs, bringing in another company potentially, replacing Second Sight will have to be carefully managed. We plan on having a face-to-face meeting with Second Sight next week to discuss and agree a way forward. So it seems as though by that stage you're getting quite clear directions on the future of Second Sight from
Yes, that's right.
the chair.
Correct.
And you're putting them into action and emailing the CEO.
I think from memory, we'd had a conversation about how to move. I had a conversation with Second Sight about how to move forward from here, or from, the day before, and how to work through the cases they've got. But we were also thinking about putting in place the mediation scheme, which eventually went into place, and they remained a key part of that mediation scheme.
Can we please turn to poll 00108-058? This is the next day. An email from Paula Venables to Alice Perkins. If we scroll down to the bottom, please. Actually, if we scroll down over the page, Alice Perkins sends Teresa Isles a message saying, "Here is the document to which I was referring. I should be grateful if you could make sure Paula sees it on her return, but no need for her to see during her holiday. Please can you make sure no one else sees it?" If we scroll up, it's her meeting note.
Okay.
If we scroll down, we can see the attachment at the bottom, and it's AP meeting with Susan Crichton .docx. The response from Paula Venables is on page 1. The bottom of page 1, please. It says, "Hi Alice, Teresa confirmed it's on file. Thank you for doing the meeting and the note. It makes me sad, but doesn't surprise me. There are 2 alerts from me. The first is your point about the bland board paper. I've just seen a bland update from Susan on this week's work, which I've immediately sent on to Chris with some concerns about lack of progress. Some issues, Second Sight costs and working party processes remaining the same as when I left last Wednesday/Thursday, and no risks flagged at all. For example, there's no colour on the fact that our external lawyers have issued disclosures on 9 cases, up from 2 weeks ago. The second alert is how much Susan sees as beyond her control, one for my full return. I'll keep close to this and to Chris, who also is briefed to deal with Second Sight cost issues." So reference there to the bland board paper. We've seen over the course of today board papers being changed, words being changed, bugs being changed to other words. The 5% issue, for example, going from 5 to 10% of cases that are going to be overturned to 5% of cases where disclosure needed to be made. Do you think that you were producing bland board papers that didn't accurately set out the risks?
I don't think so, and certainly, as I mentioned, my intention would have been to have a better discussion about the risks face-to-face, because at that stage we weren't sure what the risks were. There was a sort of range of potential risks and outcomes from the actions we were having to take, and I would have preferred to discuss that range rather than just have it set out in a board paper.
We've talked about, for example, the Simon Clarke advice on Gareth Jenkins. We're now in August 2013. Don't you think you should have been jumping up and down a bit more about serious risks to the business, serious risks to the safety of convictions?
With hindsight, probably. Yes, probably. I should have been.
Paula Vennell says to Alice Perkins, "It makes me sad but doesn't surprise me." What's your view as to whether that was a genuine feeling or not?
I have no idea.
I'm going to take you to notes of some more meetings, but first I just want to look at some events that occurred around the same time. Can we begin with poll 00142323, please? And we're going back slightly in time to the 22nd of July, so a previous week or so. This is an email from John Scott. I apologise for the formatting. I think we do have other versions that don't have all the question marks, but you can take it from me that this is an email that was sent from John Scott to yourself, Hugh Flemington, John L. Singh and others. And he says as follows: "A review has been conducted in respect of commercially sensitive and or legally privileged information, in particular with the management and exchange of information subject to the second site review. Whilst most information within this group will be legally privileged, nonetheless, if the information was to inadvertently be sent to the wrong email address or intercepted innocently or otherwise, once out in the public domain, it will be hard to control. Having agreed with Susan Crichton, with immediate effect, all information should, where possible, be placed onto a document and accesses through a password protocol. The procedure is easy to use and only takes a matter of seconds." Do you recall a discussion with John Scott in around 22nd of July relating to the protection of confidential and sensitive information?
No, I don't.
Do you think it's likely that it happened, given that there is reference in that email to an agreement with you?
Yes, I do think it's likely. And I was always of the view that if it made sense to use password protection, just to avoid, as he said, it being inadvertently sent to the wrong person.
Do you recall any conversation with John Scott around this time about concerns relating to the circulation of information relating to Horizon matters?
No, I don't think I do.
There's mention there of the second site review. Why in particular did this concern relate to the second site review?
I think it was more the general exchange of information.
Can we look at poll 00006577? We're now on the 2nd of August. So a very similar time to when these conversations were taking place with Paula Vennell and Alice Perkins. This is an email from, a letter, from Andy Cash. Who was Andy Cash?
So he was one of the lawyers at Cartwright King.
Thank you. If we can see there, it's Dear Hugh and Susan. So you were one of the recipients for the urgent attention of Hugh Flemington and Susan Crichton. He says as follows: "I enclose for your urgent attention an advice prepared by my colleague Simon Clarke. I'm sure you'll appreciate that the advice is sent as part of our brief to advise on the impact of horizon issues and to protect the reputation of the Post Office. It is fully accepted that you may wish to take a second opinion on the views expressed. This is the Simon Clarke advice on the duty to record information. Did you instruct Cartwright King to provide that advice, or was this something that was provided voluntarily?
So I have a bit of problem with the chronology here. This copy of this letter came in relatively late, and I know there was quite a lot of discussion on the timing with one of my former colleagues last week. I don't remember seeing this in this form. I think I spoke to, later than the 2nd of August, I spoke to Martin Smith, I think that's right. Right, that's what it says in my statement, I think, in relation to the advice that was attached or enclosed with this letter.
Let's look at the advice. It's POL 00006799. Do you recall receiving the advice?
Yes, but again, I think probably after I'd had the telephone call from Cartwright King, I went off to try and find what had happened to the letter.
And if we scroll down, please. Paragraph 2 says as follows. I advise that there ought to be a single central hub, the function of which was to act as the primary repository for all Horizon issues. The hub would collate from all sources into one location all Horizon-related defects, bugs, complaints, queries, and Fujitsu remedies, thereby providing a future expert witness and those charged with disclosure duties with recourse to a single information point where all Horizon issues could be identified and considered. The rationale behind this advice derived from the need to protect the Post Office from the current situation repeating itself in the future. The Post Office accepted that advice, and accordingly, a weekly conference call meeting was established so as to meet the requirement of the central hub. Over the page, please. He says at paragraph 5, at some point following the conclusion of the third conference call, which I understand to have taken place on the morning of Wednesday the 31st of July, it became unclear as to whether and what extent material was either being retained centrally or disseminated. The following information has been relayed to me. The minutes of a previous conference call had been typed and emailed to a number of persons, and instruction was then given that those emails and minutes should be and have been destroyed. The word shredded was conveyed to me. Handwritten minutes were not to be typed and should be forwarded to Pol, Head of Security. Advice had been given to the Post Office, which I report as relayed to me verbatim. If it's not minuted, it's not in the public domain and therefore not disclosable. If it's produced, it's available for disclosure. If not minuted, then technically it's not. If we scroll down slightly, it says some at the Post Office do not wish to minute the weekly conference calls. And then on page 7, he gives his advice or his conclusion. He says as follows, regardless of the position in civil law, any advice to the effect that if material is not minuted or otherwise written down, it does not fall to be disclosed is, in the field of criminal law, wrong. It is wrong in law and in principle, and such a view represents a failing to fully appreciate the duties of fairness and integrity placed upon a prosecutor's shoulders. Now, there is a discussion by the 14th of August 2013 with John Scott, and I'd like to look at that. It's POL 00139690. If we scroll down to the bottom of that page, please. There's an email from you on the 13th of August about the Wednesday call. John, as part of our remedial action, I had asked you to set up and chair this call. I have had very worrying feedback, re this call, from Cartwright King, and it sounds like this is not being chaired, the participants are unclear as to its purpose, and no minutes are being kept, or there is confusion. Now, that certainly seems that by the 13th of August you had considered the advice that I've just read.
So, from my memory, what happened is Jarnell and Hugh had a conversation to say that the calls were being mismanaged and not achieving their objectives. And it maybe at that point I went off to look for the advice, or I'd spoken to Martin. But I don't think I'd seen the advice from Simon at that point, because if I had, I wouldn't have contacted John Scott in these terms, nor would I have suggested that he then carry on to chair the calls, because that would be illogical.
Illogical or wrong?
Well, wrong. It would be wrong.
And how are you so confident, having not remembered detail of a number of meetings today, that you didn't see that advice by the 13th of August?
Well, it's just this is relatively late on the 30th. It's 8:30 in the evening. I'm not completely confident. No, I wouldn't be completely confident, but that's how I think the logic worked. But you're right, I can't be completely confident.
Because the covering letter to the advice was the 2nd of August. Why does the timing, 8:30 in the evening, mean
Because-
that it's less likely that you saw the underlying advice?
Because as I understood from the evidence that was given last week, I actually didn't get hold of the advice, physical advice, as in, till the 14th of August. And then I wrote the letter to Cartwright King, which is also in the evidence. But you're right, I can't be completely certain.
If we scroll up, please, we can read from this email. It says, Susan, and this is from John Scott, the brief given by yourself for this meeting was to provide, in effect, an under-the-radar escalation point from across the business of issues that may impact the integrity of the Horizon system. You were frustrated in regards to production and circulation of the Helen Rose report, and therefore did not want any electronic communication which may be subject to the Freedom of Information Act or disclosure. Is that right?
No, that's not correct, and that's not the reason I was frustrated about the production of the Helen Rose report. I thought that the idea of having a conference call and a single hub was a very good idea, and we should have been doing it anyway. But what I did want was there to be one single repository of the data, so that we had one version of what had been discussed, what had been agreed, and what remedies were going to take place, so it was in one place and accessible. So I didn't think it was made sense to have a lot of different emails flying around, but I wanted it in one place, so that if Cartwright King needed to find it, it would be there. If Bond Dickinson needed it, if anybody needed it, it would be in one place and accessible and maintained. Because one of the issues with Post Office, as you've no doubt realised, is that the document retention issues are complex. So that's what I wanted. Obviously,
This is a contemporaneous email. It's not a witness statement that's been written for the inquiry with hindsight. A contemporaneous email that says very clearly that you were frustrated about the circulation of the Helen Rose report and you didn't want any electronic communication which could be subject to disclosure. Why would John Scott say that to you in an email, knowing that you could easily come back and say, what are you talking about?
I don't know. But the Helen Rose report was much more about how it was prepared, why it took so long, how it was disseminated to the criminal law team. Or it wasn't disseminated.
That was a report that related to Horizon integrity issues.
Yes, the Lepton.
I'll continue. The conference calls have been set up and they're chaired by a senior manager from the security team, and then I'm briefed thereafter. I wasn't aware I had to specifically chair, but that is easily remedied. At the outset, the purpose of the call was given, and that this was an informal escalation point and no electronic notes would be taken or circulated and communication would be created. Written notes have been taken for each call and activity has been driven behind the scenes. For example, a potential Horizon glitch was raised that had been reported previously to Simon Baker. This was then managed subsequently directly with Roderick Williams and Steve Beddoe by myself in a manner to bring it under legal privilege as far as possible. What did you understand that to mean?
Presumably that something was raised by Simon, but I would presume that to have been included in the central repository.
John Scott appeared before this inquiry in phase 4, and his evidence was that you wanted things covered by legal professional privilege. Is that correct?
I think certainly there was a view from the civil litigation lawyers on the call that they wanted to try and protect information by legal privilege. And if you look at some of the early minutes, it's discussed in the call.
And you were at this stage, were you in charge of John Scott's department?
I was.
Did you therefore give him a direction that things should be covered by legal privilege as far as possible?
No, I left that to the civil litigation lawyers that were on the call.
He certainly seems to think in this email that it was you who gave that order.
I don't think I would have done.
Putting a potential horizon glitch under legal privilege so far as possible, that's very significant, isn't it?
It certainly seems so, yes.
If we carry on, the next paragraph ends as follows. However, the nature of the operating under the radar, and with my memory fading of the rationale, from Martin's perspective, it would look disorganised without formal terms of reference, electronic notes, action lists, etc. Was this a group that was meant to be operating under the radar?
Not as far as I was concerned, because there's an email from Roderick setting up the group, and it clearly states that who needs to be on the calls. We've got 2 lawyers from external firms. It absolutely wasn't operating under the radar in that respect.
He ends as follows. Clearly, I will now attend the conference calls as chair, and following on from the previous discussions and the steer below, unless otherwise directed, this will become a formal meeting with terms of reference, electronic notes, actions and appropriate governance within such approach. This will be built into the operating and governance model, and the previous notes and actions over the last 3 will now be electronically recorded and circulated. This does run the risk that more communication will be generated electronically with issues, reports and actions responded to, etc., that may include inappropriate comments, opinion, assumptions that may be subject to the Freedom of Information Act and disclosure, as in the Helen Rose report. This correspondence with John Scott is occurring around the same time as the CEO is complaining about bland board papers. Were you at this time seeking to not include certain information provided to the board and to keep information under legal privilege so far as possible?
No, I don't. That's not my recollection.
Let's look at the response to Andy Cash. That's POL 00006797. We're on the 16th of August 2013. I think we heard from Roderick Williams that he drafted this response. Do you recall that?
Yes, I saw that, yes.
Was that your recollection?
Yes. Yes, it is my recollection.
It says, thank you for your letter of the 2nd of August 2013, enclosing Simon Clark's advice on disclosure. Unfortunately, I had not seen your letter and was not aware of it until Martin's email on the 14th of August. So that was the evidence that you've just been giving about potentially not having seen it.
That's correct, yes.
But that may or may not be correct, you're not sure.
So I thought it was a telephone call with Martin, but maybe it was an email saying, have you got this letter? I don't know. But I think it was the time that Hugh was away. So it might well have come into him because he was first on the envelope. But I'm speculating.
There is a suggestion in the evidence that Roderick Williams had kept it in a drawer. What's your recollection of that?
I guess can't specifically recollect it, but it might be correct because we were so busy and because Hugh was away. And I think also Roderick had been on holiday as well.
Why would it be kept in a drawer if people were away? And the suggestion of a drawer is something slightly covert.
I don't know. I really don't know.
Do you think that there was an attempt to keep that advice quiet?
No, I don't think so.
The advice was prepared as a consequence of statements purportedly made in connection with the weekly conference calls we established to share across the Post Office Limited issues identified with the Horizon system. A key purpose of the Horizon calls is to ensure Horizon users are promptly made aware of any issues with it so that these issues can be effectively managed. The next paragraph, I'm therefore deeply concerned at the suggestion in Simon's note that there may have been an attempt to destroy documentary material generated in connection with the Horizon calls, specifically any minutes of the calls. I note Simon's advice does not suggest that material connected to the operation of Horizon itself may have been compromised. Post Office Limited is committed to conducting its business in an open, transparent and lawful manner. Any suggestion to the contrary would not reflect Post Office Limited's policy and would not be authorised or endorsed by Post Office Limited. Accordingly, the purported statements referred to in Simon's note do not reflect or represent Post Office Limited's position. That's not true, is it?
In what sense?
Well, we've seen the email correspondence from John Scott saying that that was exactly the kind of thing that he was doing intentionally. Do you think it was fair or accurate to say the purported statements referred to in Simon's notes do not reflect or represent Post Office Limited's position when you had been told by John Scott on the 14th of August that he thought that this was an under-the-radar group that didn't want any electronic communications?
I'm just trying to remember the order of things. I think that what happened was that I went and asked Janelle what had happened and why this had come to the fore. But I think that was before this had come in. But I also don't recollect having that conversation with John. I just know that Roderick sent the email to set the group up. There was some discussion in one of the first sets of minutes about privilege. I don't recollect either asking John Scott if he shredded documents or not, which I would have done had I seen the information before that email had come in. So I'm just really a bit confused about the chronology.
I can assist you with the chronology. The chronology is 13th of August, you send an email to John Scott saying that you've had some worrying feedback from Cartwright King. On the 14th of August, John Scott responds to you saying that, referring to the under-the-radar escalation point and saying that you didn't want any electronic communication. And then on the 16th of August, you send a letter to Andy Cash at Cartwright King, making no mention of any confusion within the business as to whether electronic records should be kept, but instead referring to purported statements in Simon's notes which don't reflect or represent Post Office Limited's position. That's the chronology, isn't it?
I think that's right, yes.
Yes. And why would you not be full and frank with your own lawyers as to the contents of John Scott's very recent admission in his email to you?
I think I was trying to be full and frank because I think it was the intention, my intention, that we set up this hub, we ran this properly, there were minutes, notes, and it was run from a central, file so that people would have access to it. I didn't intend for it to be under the radar in that sense.
No, but you had been told very shortly before you sent this email that the person who was meant to be chairing it saw it as precisely that.
Yes, I should have put those two things together.
And why weren't you full and frank with your own lawyers in that respect?
I think I was. I think the Post Office was committed to running that hub in the way that I've set out. I think there have been some issues with regard to operationalising that, which were obviously very significant.
Is there a missing paragraph in this letter that should have said, oh, and by the way, we have a rogue employee who totally misunderstood the brief?
I think if there's some correspondence or there's some copy documents I've seen which seems to indicate that, and it goes to the cultural point about Post Office, which is raised, I can't remember which note it is, saying that people don't want this to be recorded, whereas that was not my view, that was not my stance.
Having received Simon Clarke's advice, did you press John Scott any further as to whether anything had been shredded?
I can't recollect that.
The note in that advice about shredding, would that, in your view, be consistent with John Scott's email to you of the 14th of August?
No, it wouldn't, but it would be consistent, I think, with the type of thing that Janelle Singh had brought to my attention with regard to the confusion of the calls and what the purpose was and how we could get the items, the issues nailed down and properly described and move forward.
As General Counsel of the Post Office at this time, what investigation did you carry out into those very serious allegations that had been made in that Simon Clarke advice?
So my recollection was that I certainly went and spoke to Mr. Singh because he was on the call. I also think I spoke to Andy Parsons and I'd obviously spoken to Martin Smith, and I think I asked John Scott, but I can't remember when.
I mean, it might be suggested by some in the room that by the summer of 2013, you had now effectively drunk the corporate Kool-Aid and were worrying about having given Second Sight too much information. What would you say to that suggestion?
No, I don't agree with that.
Did you, by that stage, feel responsible for the damage that Second Sight was said to have done to the business?
No, I felt responsible, I suppose, for Alice saying she was blindsided. Alice Perkins was saying she was blindsided at the board, but I didn't, on reflection, after, I didn't consider that to be the case.
Is that a convenient moment for our afternoon break?
That is, yes. Thank you very much. Could we come back in 10 minutes' time?
Yeah.
Thank you very much.
So that I'm clear.
25 past.
25 past, yeah, fine.
Thank you, sir. Thank you, Mrs. Crichton. We're going to stick with August 2013 and just look at some other developments that occurred at that time. Can we bring up onto screen poll 00116-218, please? I'm going to start on page 2. Bottom of page 2. Thank you. Can we have a look at the very bottom email, please, and over to the next page? 27th of August, Alwyn Lyons emails Paula Venables a draft note for the board. It says as follows: Paula, I think this is here, is the message for the board. Can you let me have any amends? Would you look in particular at the HR piece, as these are my words, but you may want to change them. If we scroll down, we can see Horizon announcement of independent mediation scheme for sub-postmasters, Project Sparrow. We have today announced the introduction of an independent mediation scheme to address the concerns raised by some sub-postmasters regarding cases that they feel require further resolution. It says the Post Office, Justice for Sub-Postmasters Alliance and Second Sight have formed a working group to collaboratively develop and monitor this scheme, which is available to current and former sub-postmasters from the 27th of August 2013. So we have by now, the 27th of August, established the mediation scheme and the working group. If we scroll up, please, there's an email responding to this from Paula Venables to Alwyn Lyons and yourself. And she says, Alwyn, thank you for this. I'll get back to you on one section I'm reviewing, but wanted to get Susan in the loop on Horizon as soon as possible. She says, Horizon, I think there's too much detail regarding the release, but nothing on reassuring the board regarding mediation. They will want to know how we plan to manage any associated risk. Susan, a couple of questions to help position this. I've just read the mediation pack tonight. Page 10 states clearly that compensation can be a possible outcome. When we discussed this, the hope of mediation was to avoid or minimize compensation, but as far as I can see, the pack doesn't really suggest any other outcome. Difficult to do, I know. And so this will be the page that sub-postmasters will pay attention to. You explained that there were steps in place to advise sub-postmasters entering the process that this was a chance to be heard and not to expect compensation. However, are we planning to manage those expectations? And where compensation may be offered, you mentioned small figures in the £3,000 to £5,000 band. Can we give a range of costs? Was that your understanding of the mediation scheme?
In the sense of compensation?
Well, Paula Venables gives the impression in this email that the hope of mediation was to avoid or minimise compensation, and that if there was to be compensation, it would be only small figures.
So I think my view, my recollection at the time was that compensation could easily be one of the outcomes, and we wouldn't know what level it would be. I mean, there is some documentation which looks at the things like compensation for, I can't remember now, loss of contract or something, and there is some mention somewhere of those kind of figures, but we wouldn't actually know until we'd started the scheme.
And from your recollection in relation to this email and general conversations that were had at the time, was the business at that stage a little concerned about what the result of the mediation scheme could possibly be?
Yes, I think it probably was.
Can we turn to poll 0019445? Just very quickly want to go to that bottom email. It seems that by the 29th of August, this is an email from Chris Day to Alice Perkins, you're copied in. I've discussed this with Susan and asked her to negotiate a monthly cap of £25,000 with Second Sight. In addition, Second Sight have agreed to transition out, subject to our in-house team being sufficiently competent/independent in both carrying on with existing investigations and supporting sub-postmasters appropriately over the coming months, depending on the incidence of new cases arising and the rate of take-up. Over the page, please. Susan's view is that this is likely to be achievable by the end of this calendar year or latest first quarter of 2014. So it seems as though by this stage, Second Sight were being transitioned out of the picture.
What was going to happen, with the way the mediation scheme was going to work from memory, is that they would be part of the mediation scheme and they would look at the sub-postmasters' cases to make sure that there was enough information there for mediation, or they would be sitting in that central hub there. So it was transparent in that respect. They were still going to be part of the mediation scheme. And I think, on my part, that was absolutely a best guess as to how long it would take to do that. We didn't know. We hadn't started.
Looking back at all of those emails that we've seen this afternoon and this morning, do you think that the Post Office was genuine in wanting to get to the bottom of the problems with Horizon?
I felt I was genuine, and I thought you might ask me about the mediation scheme, so I've reflected on that. I know that I was genuine in my attempt to set it up in a way I believed would work and would work for sub-postmasters. I'm really not sure what the Post Office wanted from that at that stage.
Do you think that the executive team really wanted an independent investigation?
In 2012?
Yes.
I know that I thought it was the right thing to do. I don't know about other people on the executive team. I can reflect and say, well, maybe they didn't, but I don't know. The
picture that's painted by some of those emails that we've been looking at is that when things suddenly weren't going the Post Office's way in that independent inquiry, it seems that there was an attempt to cover that up in some way by using legal professional privilege, bland board statements, using words other than bugs. Do you agree with that?
That was not my intention at the time, from my recollection.
And how about the intention of others?
I can't speak for other people. I really can't.
Well, let's look at a file note from Paula Vennels, Pol 00381629. This is a file note that's very recently been disclosed by the Post Office. I think you may have had it only yesterday. It says Friday the 30th of September. 30th of September was actually a Monday, and it looks, from the context of this document, likely to have been the 30th of August, because we then scroll down and we can see a meeting on the 2nd of September.
I think it must have been the 30th of August.
30th of August. I'm going to take you through, as I have those other file notes, quite slowly and carefully. Purpose. Susan had asked me earlier in the week how I felt about her continuing in the business and what job I was expecting her to do. I was slightly surprised that she had raised the issue again. We had already had a conversation where I said I had wanted her to help her to restore her reputation after the board discussion. But again, I said I wanted her to do what I had asked of her prior to my holiday, i.e. to get on top of the new processes, to lead the business through the mediation scheme, and to help me use this as a catalyst to change the culture. So we listened more. So that's a reference to the board discussion of the 16th of July of 2013.
I assume so.
Did you understand that to be the purpose?
I have to say I can't remember this meeting. So I just can't remember it at all.
It says Susan was very, very angry. She yelled at me. She thinks this has damaged her reputation. She was upset that Alice had commissioned the RH review. Is that the Richard Hatfield review?
I think it must be, yes.
And that was a further review that was going to be a lessons learned exercise. Is that
That's
right?
correct.
Now, you may not be able to recollect this meeting, but can you recall not being happy with the commissioning of the lessons learned review?
I was not, no. I felt it was an inappropriate use of funds, if you like. I thought we should get on and get the mediation scheme going.
And why would it be an inappropriate use of funds?
Because it was just going back over old ground again.
She was cross that I hadn't got her the terms of reference before I circulated it to Alice, Alistair and RH, that's Richard Hatfield. She was convinced there was a breakdown of trust, especially between her and Alice, but with the board generally. Although she did say that all the board except Susanna had been in touch. We've seen previously the reference to you being worried that you were going to be a scapegoat. Is this in a similar vein?
Yes, I think so.
Susanna, is that Susanna's story?
Is that the Sheck's representative?
Yes.
Yes.
Would it have surprised you that she hadn't been in touch, or are we not to read anything into that?
Not really. I think they hadn't necessarily all been in touch. They sort of might have sent an email or popped into the office or something.
I explained I had simply not the time to give her the terms of reference. Dave Ward, Cool / CWU, Communications and Workers Union, discussion with CD / KG. Are you able to assist us with that?
I'm guessing it would be, Chris Day and Kevin Gilliland.
I said if she felt some changes were needed, then I would be happy to consider them. She suggested that our external lawyers, Bond Dickinson, should be involved. I said if that helped, I couldn't see why not and would think about it. Now, she said, I explained I had simply not the time to give her the terms of reference. Do you think that that was true?
On reflection, no,
Why not?
because it would only have meant forwarding an email.
It is clear that the RH review has destabilised her. She shouted that she was looking at other jobs. She threatened that we would have to back her, implying the importance of references. She again raised that Alice had made mistakes. I reminded her that we probably all had, and Alice had accepted that Richard Hatfield needed to be even-handed. I reminded her again that I had raised with Alice the issue of Alice also needing to be interviewed. And I said that whilst I would be asking Alice about a couple of challenges Susan raised, Alice believing Donald and Biz comments about post office cover-up, I wanted to be loyal to the chairman, as I believed she had imagined the Richard Hatfield review would be a way of moving on. There's quite a lot to unpack in that paragraph. Can we begin by looking at the issue between you and Alice Perkins? Did you feel that the review was in some way Alice Perkins setting you up?
I think that's what I thought at the time. That would be my recollection, yes.
And Alice believing Donald and Biz comments about post office cover-up. Can you assist us?
I can't remember that.
It's quite important for this.
I absolutely understand, and the problem I have is that I can't remember this meeting at all. I'm sure, it's written contemporaneously, as you've said, with other things, so I'm sure it must have happened, but it's so far out of my normal range of behaviour, the shouting and the, especially in a public place, well, anyway, but I just can't remember it.
Then says, I also wanted to see if we could get ourselves back on an even keel. Susan is clearly making lawyer's notes on everything, and I would like the two of them to repair their relationship. I'm not sure how doable the latter is, but to have it break down totally at present is not in anyone's interests. So I mostly listened and took the anger. Eventually she calmed down and I said I would genuinely like to help her find a way through this. She began to be positive again, and as we walked back to 148, is that the post office building?
Yes.
Susan suggested I join her and her HR team for her moving on supper. I thanked her and said I would be happy to do that and to say how sorry I was that it had happened so quickly, and she had helped me make the function much stronger, and I was grateful to her. At that point, is that moving on from just from the HR team, not from the whole business, or was that moving
That was
on?
just moving on from the HR team.
If we go over the page, please. There seems to be another meeting on Monday, the 2nd of September 2013. It's another note, of that date. And she says as follows: over the weekend, I reflected that Susan's request to bring in BD, I think that's Bond Dickinson, is that your reading of it?
Yes, it is.
Was more about her lack of confidence, and decided to reassure her that I was happy to take her opinions to demonstrate confidence in her. Then says, Susan then told me it didn't matter because she couldn't do her job anymore. Just pausing there, there was a second meeting, was there, on the Monday?
I'm fine. I found this note really quite confusing. I couldn't work out with whether what was reflection and what was the meeting. I recollect that with my view at the time, and it was becoming into sharper focus, that I could no longer do my time, no longer continue in my role at the post office if I didn't have the trust and confidence of the chair, the board and the CEO.
We saw that on the first page it was a meeting at Costa Coffee, Old Street. Here it says meeting room 3 p.m, so it does look as though there was a further meeting on the Monday.
Did you say it does look?
It does look.
Yes, I think that's right. It does look like that.
Susan told me that it didn't matter because she couldn't do her job anymore. The RH review was not the right action for the business. We had ruined her reputation and compromised her. Professionally, she needed to point out that the RH review shouldn't happen, as not being legally privileged, it could be detrimental to the business. But Alice would not believe her and instead see her view as defensive. Therefore, she could no longer be effective. A general counsel cannot operate if they don't have the confidence of the chairman, board, CEO. I repeated she had my confidence, and I cited other business issues in the last several days where I had sought her counsel. I'm trying to help her repair the situation. She pointed to the impossibility of her ever coming before the board. I disagreed. She would have spoken to all of the board, and I reminded her that Alice wanted an open and even-handed RH lesson learned review. We saw that earlier board meeting you hadn't been allowed into the room or hadn't been invited into the room. Did you think that from that point onwards it was or was not possible for you to effectively attend board meetings?
I suppose I came to the conclusion or the realisation it's something I never expected to happen to me, and it took me some time to adjust to what had happened and understand it. And it's sort of clear to me that I was just I felt I couldn't continue in my role, and I think that was further exacerbated by the way that the responsibility from HR had been removed from me. Now I agree that was the right thing to do for the business, but it was the way it had been done. So I think mentally I was in a bad place, I think I can say.
The suggestion in that paragraph might be that Alice Perkins thought that you didn't want to be scrutinised by the Lessons Learned Review. Was that your understanding of hers or Paula Reynolds' position?
No, I don't think so.
Could we scroll down, please? She says as follows: I wonder if Susan is overreacting to the review, but she could be right. She will undoubtedly make the legal case against it. Emotionally, she may just throw in the towel if we decide to press ahead. This may also be her way of saying she can't cope with much more pressure at present. If Susan leaves in the short term, that will be a major setback. She has stabilised the project, which is demonstrating that she wants to right the wrongs. Not my words, not hers. And importantly, the external stakeholders have responded positively, and she has the confidence of the internal team. She says not your words, but hers in terms of right the wrongs. What did you understand that to be a reference to?
I think she's referring to the fact that's how she felt about the second site review and my handling of the second site review.
Could we scroll down, please? I need to find a way of calming this down and buying us some time to think carefully. We can do a lessons learned internally, and if we do it ourselves, then there could be some reconciliation. How we handle this will say a great deal about the values of the business. And then she provides some further reflections. She says, in both meetings, Susan was very emotional. She's hurt, her ego and self-esteem have been undermined. She swings between wanting to get away from it all with a settlement and leave immediately, to building the case to fight and to defend her reputation, to accepting that the most satisfactory outcome would be to restore her reputation by managing the mediation scheme through to a satisfactory ongoing process. Just pausing there. Is she right there? Is that a fair reading of your feelings at that time?
Reading this back, because it is quite a blur, it probably is, but I really can't remember specifically. I'd been a lawyer for a long time, then I'd worked in a number of different companies. I never expected to find myself in this position.
Each time we finished the meeting positively. Susan had said to me prior to my leave that she would never have put a business she worked for in the situation we found ourselves with Second Sight Interim report, and she wished she had never allowed Alice to persuade her to do the independent review. She should, in her view, have resigned over it at the time. That suggests that you regretted getting Second Sight involved.
I didn't regret getting Second Sight involved. I think what I regretted is that I hadn't been clearer, if it was appropriate, about my role in the Second Sight review and what I meant by being independent.
We've seen some evidence and some documents that refer to effectively you convincing Alice Perkins to do the independent review, and here we have the suggestion that in fact it was the other way around.
I think Alice was driving the independent review, and I think in her notes you see her initial intention that the MP's cases should be reviewed, but that gradually cooling as we go through the process.
And what reasons do you think there were for that cooling?
The length of time, so practical, I think, the length of time it was taking, the cost it was taking, and the fact that she considered I wasn't controlling it appropriately.
And what about the damaging things that Second Sight had discovered relating to
The
Horizon?
Post Office. Yes, obviously, they would be included as well.
My reflection on what happened with Second Sight as I write this today, the 2nd of September, is that Susan was possibly more loyal to her professional conduct requirements and put her integrity as a lawyer above the interests of the business. She did not communicate clearly what she was concerned about. If, as she says, she felt compromised personally and for the business by being asked to manage Second Sight more closely, then her misjudgment was that she did not make that clearer to me on the 2 or 3 occasions that I asked her to do so. Do you agree with what's said there?
Yes, sir. Well, as I say, I can't remember this conversation. Oh, it's her reflection, isn't it? So this wasn't a conversation that we had. This is her thinking about it afterwards.
Yes. So was, for example, managing Second Sight more closely, did you see that as in some way in conflict with your role as a lawyer?
I think what I would have said was that I wanted to ensure that their report was independent, and I wouldn't try and control them in a way that didn't give them access or ability to write the report in their way, provided it was evidence-based.
Reference there to putting your integrity as a lawyer above the interests of the business. What did you see your role as in terms of being general counsel? Was it integrity as a lawyer, or was it interest of the business? Were they in conflict?
I had never had experienced a situation where my integrity as a lawyer was in conflict with the business that I worked for. I was just very focused on delivering the independent report from Second Sight. So if that meant that I put my integrity as a lawyer above the interests of the business, then possibly that's what I did. I didn't see it quite in that way at the time.
Susan believes the person who compromised her is Alice. Alice met James Arbuthnot partway through the review, and according to Susan, Alice agreed with James Arbuthnot that Second Sight had to keep the JFSA happy. Susan believed that an independent review meant that she would not then intervene to change the biased opinions that Second Sight reached, because they were keeping the JFSA happy. It took some strong persuasion for Susan to accept, which I'm clear she did, as she was disappointed with it, that the first interim report needed Second Sight to amend it. The board and the external stakeholders only saw the second version. Can you assist us with your views on that?
So my recollection is that when I got the first version of the Second Sight report, which hasn't appeared in any of the documents, that some of the flavour of the report was not focused on the evidence, but rather focused on a somewhat emotional interpretation of the facts. And this was when I had the discussion with Second Sight to say, you know, what you write needs to be evidence-based and needs to be put in those terms. But we had a discussion about it. I wouldn't have been able to force them to do that, but we just had an exchange of views.
Could we scroll down, please? Wider performance context. Up until this time, Susan had been a wise, if risk-averse, we had discussed this, general counsel. She worked long hours and professionally for the business, steering the post office through the MDA and MSA during this separation from Royal Mail. It says, if risk-averse, we had discussed this. Can you recall a conversation with Paula Venables about you being risk-averse?
No, I can't. And I wondered if...
That
no.
could be a discussion with somebody else, perhaps? Or...
I wonder if she discussed it with Alice. I don't know.
It says further down, she agreed that she would relinquish the HR function. When we were faced with the urgency of handling the Second Sight interim review fallout, ministerial statement to Parliament, high-profile media, etc., I told Susan that I was minded to implement that decision immediately so that she could concentrate on Second Sight handling. Faye would take on the HR reporting. In the interim, Susan agreed. HR announcement. When I returned from holiday, I was told by Alwyn that Susan had been upset because I had not spoken to her about the timing of the announcement. She indicated that could be construed as constructive dismissal, but then I qualified her comments by confirming she did not know and had not been involved twice in the decision-making process. Is this related to you relinquishing the HR role?
Correct.
Yes. And what's your recollection of that?
So I don't remember discussing it twice. In retrospect, with hindsight, it was absolutely the right thing to do. Just the HR made that job very difficult to do.
Can we please look at poll 00381658? Before we look at that other document, what are your general reflections on this note, having now seen it and going through it?
I find it quite shocking that I got into that kind of situation. As a personal reflection, it's quite distressing, I think. I must have been in a really bad state.
And does it give you any insight into how the company was run at the time?
So if I put myself in Paula's position, and I have been in this position with people I've worked with and for over the years, I would have packed myself up on a month's sick leave and said, don't come back till you feel better and have got things in perspective.
And did that happen?
No. I mean, I don't know whether you're going to go on to it, but shortly after this, I had already taken some legal advice, and I gave Paula Venables a without prejudice letter, which set out the terms on which I would agree a settlement to leave Pol. And I left Pol effectively at the end of September as we went on holiday. I came back in for a day or so in October, and then I was on gardening leave in November.
Can we look at Pol 00381658, please? This is an email exchange between Paula Venables and Alice Perkins of the 7th of September 2013. So the month that you've said you effectively left. She says, my approach needs to remind Alistair, who was Alistair, sorry?
I think that's Alistair Marnett, the chair of the ARC.
Where we left off, then paint the story to arrive at the conclusion carefully, especially as the last time we spoke, I'd been in the place of trying to help Susan repair the damage, so that will be a change. I think he will understand. Alistair had raised a couple of questions regarding Susan's judgment, but less than others. Regarding speaking to Susan, I had a tip-off from Alwyn that Susan may raise it with me on Monday herself. They spoke midweek. Susan said it was making her ill, and she didn't see how she could continue having lost the confidence of the board. And it says exactly the same conclusions, although that makes it slightly easier. If she does raise it, people can change their minds, not tidy. So I shall wait and see what happens. Either way, assuming Susan is in 148, we will have the conversation on Monday. I'm speaking to Faye this weekend, as we'll need to be thinking about which lawyers we use, interim cover, and about business messages, and indeed, when Susan goes, it sounds as though she wants that to be straight away. Much will depend on Susan's state of mind. I have been in situations like this where people have been helpful and suggested the best outcomes themselves. Susan is capable of doing that, but I'm not holding my breath. I hope this sounds calm. I am on the outside, on the inside. It was never going to be easy, but it's nothing to do with what Susan's going through, nothing to what Susan is going through, irrespective of what caused it. Thank you for your support, and helpful questions are always welcome. Irrespective of what had caused it, I mean, did you believe Paula Venables to have understood your reasons for leaving?
No, I don't think she did.
And why not?
I don't think she understood my point about this has to be an independent review. We can't manage it or manipulate it in the way that possibly Alice was expecting me to do. And this is all supposition on my part. Either way, I had decided that the time was to draw a close to this chapter in my career.
Can we please look at UKGI 00007316? These are key points from a second site meeting that relate to after your time. It says as follows: interesting snippets include Ron Warmington used to work with former Pol General Counsel Susan Crichton at GE. That's how they were introduced to James Arbuthnot. Second site link the change in approach by the Post Office to Crichton's departure in November 2013, according to LinkedIn. A slight dig at how the Post Office are on their third or fourth general counsel since Crichton left. In Henderson, worked for the CCRC for 4 years, said they take a very narrow and technical view of miscarriages of justice. Were you aware, I know you weren't working in the business, but of any change of approach of the Post Office after you had left?
No.
Did you have any discussions with Second Sight, for example, after you had left?
No, I don't think so.
Looking at the way things were going when you did leave, do you think it was likely or unlikely that the Post Office would become more restrictive towards Second Sight?
I suppose reflecting on the discussions today that they would become more restrictive, although I genuinely really hoped that the mediation scheme might move the process forward.
So I have a number of miscellaneous topics to move on to. It's been quite a long day today. I'm in your hands. We have plenty of time tomorrow. I can either start on those topics.
Mr. Blake, if you're trying to persuade me that after a long, hard day we should stop now, then you needn't say any more.
Thank you very much, sir.
I'm sorry, Ms. Crichton, that you'll have to come back tomorrow. I'm grateful for you to agreeing to do that. These are arduous sessions, and in making the observation, which I did, about Mr. Blake doesn't need to persuade me any further, rest assured I've had regard for you as well. And although I have no doubt that you want this over as quickly as possible and as efficiently as possible, there's a limit to how many questions you can reasonably ask to field in one day, and you've fielded a good many. So I think it's time to stop, all right?
Thank you very much, sir. Mrs. Crichton is a lawyer and will have well in mind the prohibitions on speaking.
Yes, I'm sure she will. I should think it's the last thing that she'll want to do is to talk about this. But if you do get tempted to talk about it, Ms. Crichton, resist the temptation.
Thank you, sir.
We're back at 9:45 tomorrow.
9:45, and I'm reminded that there will be a fire test, as usual, on a Wednesday morning at 10 o'clock. So I simply propose that if you're still asking questions, as I assume you may be at that point, Mr. Blake, you simply stop very shortly before 10, and we just all sit quietly through the fire alarm and then start again.
Yes, that's correct, sir.
Fine.
So I'm reminded by Mr. Wallace that today is 3 years since the quashing of the convictions. No doubt that those present will be marking that today.
Well, I have no doubt that as each year goes by, never mind 3 years, that will be something which is always embedded in the minds of very many people. All right, see you tomorrow.
Thank you very much.